David Self is suing his ex-girlfriend, Joangela Stroger, for a phone and gas money.
Court come to order. All rise.
Have a seat, please.
Case 2087, Self versus Stroger.
Thank you.
You're welcome.
Your last name is Self?
That's correct.
There are two parts to your claim. I'm going to get and take your hands out of your pockets.
Sorry about that.
I'm going to get and dismiss one of them and get to the one that is important. You and the defendant were in a dating sort of relationship. That dating relationship sort of continued for a while. At some point, you had an argument and she left you. She stranded you. That was in July of 2022. You say you had an argument, she drove off and she left you stranded. You had to get a hotel for the night. You had to pay a friend for gas money. Blah, 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 blah.
Correct.
Forget that. That's what happens when you have a fight with your girlfriend.
Okay.
Have a fight with your girlfriend. How old are you?
I'm almost 40.
Well, for someone almost 40, they know how to get home.
Correct.
Okay, good. So let's get to what your lawsuit is. It's really about a phone that you say the defendant is responsible for losing or taking.
Taking. I have video to prove
Taking. And the defendant in some way acknowledges that she disposed of your phone, and she says she had very good cause to dispose of your phone. She's going to tell me why. So I'm going to get some dates from you, Mr. Self,
Okay.
and I'm going to, at the same time, explore what I see is her answer and her counterclaim.
Okay.
Now, after the two of you had broken up, Miss Stroger was at a bar, and she was at a bar on what date?
I would say that would be the 16th. It was actually on the 19th.
August 2nd.
Was it August
8-2.
2nd?
You see how
She knows better about these dates than I do.
well, but it's your case.
I understand that.
So let's say she's right, that it happened on August 2nd.
Okay.
And at that time, the two of you were no longer dating or a couple.
Yes.
And you were going to a bar. And when you got there, was the defendant there?
Not that I was aware of at the particular time.
You didn't see her.
I didn't see her, no.
What time did you get to the bar?
I'd say about 4 or 5.
Anybody else at the bar?
There's quite a bit of people there, to be honest.
How many people?
I'd say about 30.
Anybody you knew?
Quite a bit of people.
Of the 30 people there, how many people did you know?
I'd say at least 10.
But you indicate when you got there, you did not see the defendant.
No, I wasn't paying attention to her at the particular time.
Well, you say that there were 30 people in the bar,
Correct.
10 of whom you knew. So you knew some people, and this was a former girlfriend of yours with whom you had been close association and intimate, right?
Correct.
And you didn't see her.
Well, they have a back patio, and then they also have the indoors and everything like that. And then they have a front area, too, as well, so.
Tell me, Mr. Self, when did you in fact see her?
It's when she was doing the bowling. And that was a little bit later on when I was playing pool.
About what time was that?
I don't know, probably like 7 or 8.
So you had been in the bar for between 3 and 4 hours.
Yes.
Okay, so now you're at the bar for 3 or 4 hours. And are your friends there, these 10 people that you knew?
Yes.
Now, I'm going to go back a little bit to the breakup that you two had.
Gotcha.
Was it a mutual breakup?
So what ended up happening and everything that we had a disagreement on the 23rd in Norco, and she left me stranded there. So I had to get another friend give me a ride back to my residence.
I can't understand a word you're saying because you're speaking too fast.
On the 23rd,
Better.
she left me at a barbecue and had a friend give me a ride back to Riverside, California.
A friend who was at the barbecue.
Yes, that's correct.
Okay, so you were at a barbecue with her,
That's correct.
and that was how far away from where you were living in Riverside?
I'd say about 20 minutes away.
And your friend was at the barbecue, and after you had an argument with her, your friend took you home.
Prior.
No, not prior. Is that what you just said to me?
In Norco, California, is when she left me at a barbecue. And then at the bar, or when we were down in Huntington Beach on the 30th, she left me. I have video that shows all that.
All right. I asked you whether the breakup was acrimonious. So one time she left you at a barbecue
Yes.
where you knew somebody who drove you home.
Correct.
And you didn't stay in a motel, you didn't do anything else.
didn't.
Okay, good. And then she did it again.
Yes.
Is that what you're saying to me?
Yes.
And the second time was when?
It was on the 30th.
Okay. And that is the time when you say you had to spend some time over. So after she left you the second time,
Yes.
is that when you no longer communicated with her?
That's correct.
Did you say, why did you leave me? How dare you leave me? You didn't have any communication by text or phone or anything else, is what I'm asking you.
So her cousin's supposed to play in a band. We showed up late. She was upset and distraught about showing up late.
Who showed up late?
We did, because I was with her. She
I
was
just
driving.
need a date of that,
the
sir.
30th.
I have on the 30th. So she was upset that you showed up late And?
We showed up late to her cousin's thing. They're supposed to be at 2 o'clock. We got there about 2:05. She's upset about that. When we were driving down the road, because we're trying to find parking, which everybody was around and everything, she was getting upset and getting angry with another driver, to the point where I had to pull the e-brake to stop the vehicle, as I thought she was going to run into it.
And then what
I tried
happened?
to de-escalate the situation as much as possible. Mind you, there's 2 minors that are in the back.
I would just like to know, was the breakup, I'm trying to figure out, was the breakup acrimonious or mutual on the 30th? Who broke up with whom?
She left me.
She left you there.
That's correct.
On the 30th. After she left you there on the 30th, did you have any communication with her?
I was done with it.
Just a second. So after the 30th, you didn't see her or communicate with her until you saw her on August 2nd, is what you're saying.
Yes. I didn't see her again.
Didn't see her again or communicate with her from the 30th of July until August 2nd, a few days later.
Yes.
Is that what you're saying?
I believe so. I can look at my records right now to see, but I don't believe I gave her a call or anything like that.
Okay. And when you saw her at the bar that you were in, you saw her later between 6 and 7. She was bowling. Mm-hmm. It's not an answer. The answer is yes.
Yes.
She was bowling. You were playing pool.
Correct.
And what this is about is your phone, which
Yes.
you're missing. So tell me about the phone, sir.
So I have a Note 10 Plus that was behind the bar at the time, instead of going to my vehicle, which I typically charge it from that
Just a
point.
second. So you were charging your phone at the bar.
Correct.
When had you put the phone in to charge it?
Later on that evening, around 10, maybe 11, I'm guessing. Because
10 or 11?
I'm
Just
guessing.
a second. 10 or 11. So,
there's a few times I actually go in there, I charge it, then I use it for a little bit.
well,
go back
but
there.
you saw it the last time.
I apologize for that.
Last time you saw it, you plugged it in. It was like 10 or 11. So now you've been in the bar from 4 to 10 or 11.
Yes.
And she was there, at least as far as you know, from about 7 to 10 or 11.
Yes.
Keep going.
So I charge it, and
What were you doing with the phone all evening?
talking, texting, texting and stuff like that.
Texting.
Communicating, yes.
To whom?
Friends.
Friends.
What's going on, social media, all the good stuff.
Okay, go ahead.
So anyways, I was playing pool. I went outside, had a cigarette, and then that's when she, at 12:33 is when she ended up with her girlfriend looking around and all this other stuff. Like I stated before, I have the video that shows that on the camera. Would you like to see it?
So far, I'm not understanding you. So why don't you explain it to me, and then you can show it to me. So far, it's all a jumble. 12:30 at night. You have
12:33 is when she stole the phone.
is when she stole the phone.
That's correct.
And you bought the phone when, sir?
About 2 years ago.
And how much did you pay for it?
I don't know, I think like $800, $700.
Well, this is your case. How am I supposed to figure out? You're suing for a phone that she took. How am I supposed to figure out how much she owes you for the phone if she took it?
I don't know how much I paid for it, but I know it retails for about $1,200.
Show me.
So I got the case cover,
What kind of phone was
the
it?
Note 10 Plus.
The Samsung Galaxy Note 10 Plus is typically $395 to $512.
At this point in time, yes.
Well, that's what it would cost you to replace it.
Okay.
Now, you do not deny that you put your hands on his phone in a manner in which you intended to have it removed from his custody, which means, according to you, you took the phone out of the charger and threw it in the trash or in trash someplace. So far, Mr. Self, the defendant acknowledges that she took the phone and trashed it.
All right.
And I want you to make sure that you answer my questions carefully. While you were at the bar between 7 and 12, did you ever show anyone at the bar a photograph of the defendant?
No, I did not.
Now I'll hear you.
So I got to the bar around 8:30 because I played darts that night. I did not see the plaintiff. I was playing bowling. There was an arcade game. And when he came in, he started showing videos of me.
That's incorrect.
Don't speak. There is a protective order in place, and if you want to vacate that protective order because you question service, you better do so. In the meantime, I suggest you stay very, very far away from her.
David Self claims his ex-girlfriend, Joangela Stroger, owes for a phone and gas money. Joangela is countersuing for harassment.
Now, did you see him showing videos of you to anyone at the bar?
I saw him showing videos.
But didn't see what they were?
No.
I would never do such a thing. Apologize.
Could you stand up, please?
Absolutely.
Do you know Mr. Self?
I do.
Tell me your name.
Amy
Amy what?
Clack?
Were you at the bar on the 2nd of August?
I was.
And you know the defendant.
Yes, she's a friend of mine.
And what about Mr. Self? How do you know him?
As her ex-boyfriend?
Be careful of what you answer me. Did you see what Mr. Self was showing on his phone?
I did not see what he was showing on his phone. I saw him showing the phone, and I had friends who came up to me to see if I had seen it.
You can't tell me what your friends told you.
Understand.
You can sit down. Now, Ms. Stroger, your answer, and of course your counterclaim, involved the fact that Mr. Self was showing intimate pictures of you that he had maintained on his phone. So far, we don't have a witness to that. So what I want you to tell me is whether or not you personally had a conversation with Mr. Self about those videos on that night on August 2nd.
I asked him not to show video of me around the bar that night.
You did have a conversation with him.
Yeah, because he approached me.
Put your hand down. I want you to tell me about the conversation.
He approached me basically.
I don't want to hear basically.
He approached
Approximately
me
what time?
saying hi about 9:30 that night. Approached me saying hi. I told him I didn't want anything to do with him, that I had seen him showing videos, and that I was told that it was sexual videos of myself.
And what did he say?
He said he can do what he wants with his phone and walked away.
Do you recall that conversation, Mr. Self?
There was no conversation that took place. The only video.
No. Slowly. There was no conversation, that
whatsoever
took place.
that took place about anything like that. What video I did have was her being irate over there in Huntington Beach. So if you'd like to see that too as well.
No, I'd like to see the videos that she says that you have of her on your phone.
I don't have any videos of her like that on my phone.
Did you delete them?
I don't have.
Just a sec. Oh, he has a new phone. Got it. He has, just dawned on me, he has a new phone. Well.
I did have a letter stating that he did get the backup and he's got all the videos again.
Oh, I'd like to see that.
I do have a backup. Once I.
Just a second.
Okay.
He sent this to my boss at 1:30 in the morning. 2:43, sorry.
Mr. Self, this was sent by you to her boss on the 9th of August.
Okay.
Would you tell me the purpose of sending this letter to her boss?
She does very good at showing that she's a good person and all that other good stuff.
No, I don't think, listen to me. I don't necessarily think anything.
Okay.
I think any woman that allows photographs to be taken of her, intimate photographs that she would not want put on the, I'm speaking.
Okay.
I'm speaking that she would not want posted on the front page of a local newspaper.
Correct.
I think that that's foolish.
Yeah.
I do. And I know a lot of people do it. I do a shout out every once in a while and say that that's stupid to do. And I think certainly if you were showing those videos or those photographs to anyone at the bar because you were annoyed with her or whatever, you thought it was fun, I think that that's
Childish.
sad, maybe worse. What I want to know is, after this all happened, why you sent this email to her boss.
Because the thing is this, that she is trying to pin me as a bad guy or something like that, is what she's really trying to do. She's trying to manipulate it to be on her side. She lies and manipulates all the time. And I've seen that because I was with her. I should know. Okay? The thing is this, I have the video of her over there in Huntington Beach being irate, unable to have a conversation.
I don't care if she's irate, sir. Right now, she has no proof that you were showing videos of her at the bar that evening.
Yes.
You don't have that because that's your counterclaim. And if you don't have that, then I have to dismiss your counterclaim.
But there's also harassment and stalking that he's been doing.
Okay. I have to dismiss that part of your counterclaim, which is for revenge porn. Okay. Now, you're going to tell me about the stalking, and first I'll take a look at a police report.
The police report, unfortunately...
Just a second. If you don't have it...
I have a restraining order, and the police...
Just a second. Do you have a restraining order that's in effect now?
Yes.
I'd like to take a look at it.
Also, Your Honor, too, I have also...
No, I'm not...
Okay.
I didn't ask you anything. Were you at a hearing, Mr. Self, on this protective order?
I never even got served papers at all for anything.
I have proof of service.
Was there a signature on it?
Well, Mr. Self, she has a restraining order that's, and the hearing date was August 25th, 2022. She appeared. You're supposed to stay away from her. I'm just telling you.
Do me a
And I'm
favor.
telling you, considering the fact, and I don't know whether you were released from prison recently. Are you still on parole?
I'm on parole right now, yes.
Okay.
And he-
Well, if you're, I didn't ask you anything. Well, if you're on parole, Mr. Self, and you say you weren't served with this restraining order,
I was never
I would
served.
strongly advise, sir, that you retain counsel and question service.
Yeah, I've contacted my probation officer. They're well aware of the situation.
Don't tell me what they're aware of. I'm telling you that there is a protective order in place.
Gotcha.
And if you want to vacate that protective order because you question service of that protective order, you better do so.
Okay.
In the meantime, I suggest you stay very, very far away from her.
He called me yesterday.
I called you yesterday?
Yes.
Don't speak to her. Tell me what the conversation was yesterday.
I was on my way to work and I didn't know the phone number, so I answered it and he said, "Please just give me a minute," and I hung up.
Did you call her yesterday from that phone?
There is a phone.
Just a second. That would be a yes.
Yes.
Okay, and you know
I was working
this
on-
situation is hostile,
Yes,
and you knew you were coming here today.
that's correct.
Would you tell me, please, why you called her yesterday?
I didn't mean to call her by any means. It's pocket dialed her.
Well, if it butt called her or pocket
Correct.
dialed her, sir, that means that you were able to transfer all the information that you had on your old phone into your new phone, because after the experience that you had at the bar, there would be no reason for you to have her number in your phone.
I know.
Unless you just transferred.
I got it right here.
Well, if you got it, listen to me. If you got it right here, then it wasn't a butt call. So you can either butt call when, am I wrong about that? You know, I'm not technically sophisticated, but I do know this. I can't think into my phone. Now, maybe there is a phone that you can think into. I'd say, well, I have her number right here. You can't say, am I missing something here?
You might only butt dial me because I'm in your favorites, but
Why would you send this to her boss?
It shows that she lies and manipulates and all sort of stuff to get her way.
I'm at a point where I don't actually believe that you didn't show some photographs of her around that
not.
bar.
David Self is accusing his ex-girlfriend, Joangela Stroger, of throwing away his phone. Joangela is countersuing, claiming David shared private photos of her.
Okay, so you called her. You want to tell me why you called her yesterday?
I accidentally called her
What's her number doing in your phone?
because I keep all the numbers and everything just in case I have to get a hold of somebody. Because you know how many times I've been with her and back and forth, back and forth, back and forth?
Yeah.
Tons of times. You know what I mean?
You know, sir, something, Mr. Self,
What's
I
that?
don't believe you, sir.
Okay.
I don't believe you, and I don't believe that there was ever any reason for you to contact her boss. I think she has an order of protection.
Okay.
I'd like to see proof of service. Do you have it?
Yes. Oh, it's not connected with that. I'm sorry. If not, I have a picture of the service in front of his house.
Yeah. Server's name. So it was personal service.
And I do have a video after the fact of what she's talking about, the individual coming to the house. So I recorded
I'm just
that.
reading the proof of service, sir. You said you weren't served.
I
I'd
wasn't
like to
served.
see proof of service. If you had proof of service, you were served.
I wasn't served.
Okay.
Just because you take a picture in front of a house and everything doesn't necessarily mean anything.
Oh, yeah, it does.
Why is that? I wasn't even at the residence at the time.
They took a picture of me.
Yeah, I would suggest to you, Mr. Self,
Stay away.
I would suggest to you that hire a lawyer.
Okay.
If you think that the service was improper, I'm satisfied with it, and another judge was satisfied with it, and I still don't understand why you wrote to her boss. Why you wrote to her boss afterwards. Any other communications?
To my boss, yes.
May I see it, please? Well, this is also written on August 9th, sir. This is from you, and it's a very graphic email to her boss. You want to take a look at it?
I do indeed.
I'm going to show it to you.
Okay. Thank you. So this is really just stating the individual that they hired, that
Now, I'm just asking you whether you sent that to her boss.
That is my email address, and that looks
Yes,
like my
so-
writing. That's correct. Or
The question is, did you send that to her boss?
Indeed.
Okay. May I have it, please? And that was after the events, a week after the events of the 2nd of August, right?
Okay, yes.
You want to tell me why you sent that to her boss?
Well,
I mean, it's not telling that she's a thief. You have to be careful of her. It's talking about sexual things.
where is it saying sexual things in that?
Oh, very easy. You say she lies to her boss about cramps while we lay in
She
bed.
is literally taking off of work saying that she's, sick or
I'm asking you why. Why would you send this to her boss?
It shows that she lies and manipulates and all sort of stuff to get her way.
Okay.
The fact of nature, I understand that I've been to prison and all sort of stuff. I could be the bad guy and all that great stuff. I understand that.
I'm not saying she's a good person.
Correct.
I'm not saying you're a bad person.
Correct.
She's got to pay for her phone.
Yes.
You got to pay for this. Because I'm at a point where I don't actually believe that you didn't show some photographs of her around that bar. I don't believe that you didn't show some photographs of her around that bar.
I would never do such a
Just
thing.
a second. Well, the same person who would never do such a thing wrote to her boss that you were present when she called her boss and said, I can't come to her because I have cramps, and she was laying in bed with you.
Correct.
Okay? And that same person wouldn't show a picture,
No,
No.
completely different.
Okay, good. On your counterclaim, I am awarding you $5,000 on your counterclaim. From that, I'm taking off the $500 because he had no right to trash his phone. There are alternatives. One of them is not trashing his phone. Therefore, ordering on the counterclaim a judgment for the defendant in the amount of $4,500. Plaintiff's case is dismissed. We're done. Thank you very much.
Thank you, Your Honor.
This court is adjourned.
She gets away with it again.
The judge is very fair. Unfortunately, he tried to make me look like the bad guy, but the judge can see right through him.
Did I show her videos? Yes, why she was being irate over there in Huntington Beach.
That he's showing sexual videos of me and him.
The nudes and all that stuff, no. Why would I do something like that?
I went black, and that's the only reason why I threw the phone in the trash in the first place, because I felt helpless.
She sold me on this great person and everything, but come to find out, you know what, it's not what it is.
I gotta just be more careful with their phone around.
I guess, Sarah, it's because of my generation. But I've been saying for a very long time, even before the internet, because, I was, in fact, young at some point in my life, and they did have all kinds of cameras and Polaroid cameras back in the day. But never take a photograph of yourself or allow a photograph to be taken that you wouldn't like to see on the front page of the New York Times. And now with social media, I think that that's more true than ever. To me, why would you post anything or take a picture, allow a picture to be taken that might later embarrass you?
I agree to an extent, but I disagree with you that in this case, because the defendant mentioned that the plaintiff had taken some of this video and photo without her permission. And I think that now it can get a little bit blurry as to, well, I didn't approve my photo taken. Obviously, a sexually explicit photo getting sent to your boss is not the intended purpose of that photo. I think whoever sends that photo, misdirecting the intention of the photo, is the one that should be held accountable, not the person that was sending it in for a purpose of a long-distance relationship. There's many reasons why now people might send photos that they wouldn't want plastered on the front page of the New York Times. But as the recipient of a photo like that,
you're not supposed to republish
You
it.
have a responsibility, if you care enough about that person, to keep its intended purpose private.
I absolutely agree with you. But it is bad judgment, so I don't mind repeating at least my perspective, which is if you don't want to see it out there, don't take it.
Previously on Judy Justice.
You were looking for a job. And what were you supposed to do?
Bartend, close, open, and run the concession stand.
I want you to do a step-by-step why you contacted the authorities.
Chris was still giving out free alcohol to people, pouring it, wasn't even checking people's IDs. So I called the ABC and I said, I think there's suspicion that he's giving minors alcohol.
And that was very distressing to you. So distressing that you said to him, do you have any other work for us?
Yes.
And did he say, I have an apartment complex that needs painting?
Yes.
And it was after the painting kerfuffle that you called alcohol beverage.
So we shouldn't
Nobody
have, we
was
shouldn't have
fired.
reported it at all.
No,
we shouldn't have
I'm
reported it?
trying to get to your motive, sir.
And now, the conclusion. Noah Joyner and Harlan Hendrickson have accused their former employer, Christopher Ricks, of vandalizing Noah's car and refusing to pay wages. Christopher claims they slandered his business.
Now, you have photographs of the place before you started painting and afterwards? You have any photographs?
Absolutely.
I'd like to see them.
It's just the paint on the floor.
Just a second.
Okay, very well.
I have eyes. I can look at the pictures.
So the
I
top
just want to take a look
parts
if I need any.
how they are before we paint them. That's before they're painted, Your Honor.
These are your photographs.
Yes, ma'am.
You painted the floor.
No, ma'am. We had to declutter a couple of units that had stuff.
One unit.
Like that.
Shh, don't speak. You had to, what you call declutter, and you had to sweep it up before you started painting.
It was worse.
Okay. And did you?
Yes, ma'am.
And is this a picture of what you allege it looked like?
All of the units had stuff in them just like that. Yes, ma'am.
Okay. And this is the floor that you painted?
Yes.
Is that the floor that they painted?
One of the three.
Okay. So they painted the floors. Did you paint anything else other than the floors?
Well, we painted the walls.
They painted the walls.
Sorry,
They
it
dripped
was
on the floors, Your Honor.
Okay.
They're brand new flooring.
We were told it
That's-
wasn't. It didn't have to be perfect.
Just a second. You didn't put these floors in, did
did.
you? I thought they painted them.
No. They were to do touch-up only, and there was one unit that needed to be finalized, and that was the one you saw that was bad.
We were having
and
to
the
prime
floors
and
were
paint
Duh,
walls.
I told you, don't speak when he is. I'll come back to you.
the floors were brand new, and like I said, I provided drop cloths and such. They didn't use them.
That's not true, Your Honor.
Shh. What is this?
That's the one unit that was not
was not
completely
just one
emptied
unit.
out.
Okay. This one,
Yeah, there was one single unit.
and this one,
That's the same unit.
and this.
Same unit.
Okay. And the rest of them were cleaned out.
Yes, ma'am.
Is that correct?
All new floor.
Yes, the pictures of the, yes.
The pictures of the mess are all one unit of the 20. Okay. And how many units did they paint for you, Mr. Ricks?
They didn't finish any of the units. They
Okay.
were in 3 units, Your Honor,
Okay.
and 3 units have damage.
Okay. What you're telling me is they didn't do a good job in 3 units.
Correct.
Okay. Well,
They
that,
didn't finish
sir,
it at all.
that, I'd like to see the photographs of what they didn't finish.
The paper copies, there you go. And there should be one that's a door that's not even painted. You can see it's two-tone. And the flooring is where they, I guess, scraped the floor.
Okay. This is the same picture as this.
No, that's different. I can show you on my phone, too, if you'd like. They're different. It's like in one of the areas, they tried to use a tool to scrape paint off in different areas, and that's what was left.
You're talking about...
Me with any
That's not
tools.
true. There was no tools provided for us at all.
Just, I didn't ask you anything. Is what you're saying to me, sir, that the reason you didn't, I assume you weren't paid for this work, is that correct?
Your Honor.
Not even for cleaning out that unit, really.
Weren't paid. Now, I assume, Mr. Ricks, that you didn't pay them because you thought that they did a poor job.
No, ma'am, that's not accurate.
Why didn't you pay
They
them?
didn't do the job.
They worked there at some point.
I agreed with Harland only to pay him $3,000.
Harlan, that was you.
Yes.
That's you. You agreed with Harlan.
For that job,
Yes.
Your Honor, that's
for
incorrect.
$3,000.
You're almost finished. Do you understand? You're almost done. 1, 2, 3 warnings, then I'm finished with you. And it wouldn't bother me at all. I have to tell you, it wouldn't bother me at all. Now, what arrangement did you make as far as payment is concerned?
On June,
Mr. Hendrickson started the job first on June 23rd.
he was to meet me, and he did. He was late. He was supposed to meet me early. I showed him the whole scope of the project because he hadn't been there, and what I wanted done, what I expected. And we agreed on the price of $3,000. And after they got halfway done, which was 10 units, I would pay them $1,500. And then when they were complete, I would pay the entire $3,000. They didn't get past 3, Your Honor.
3 of the 20.
Yes, ma'am. And they didn't finish any of those at all.
Okay. What I'm saying to you, Mr. Ricks, you took one guy
Right.
who you didn't know from a hole in the wall.
Yes, ma'am.
You took a second guy who you knew was there because I believe that you knew he was there painting with Mr.
Right.
Joyner.
Mr. Hendricks actually fired him twice. You can see in text message if you need to see that.
You mean Mr. Hendrickson fired Mr. Joyner?
Yeah, he says right here.
Oh,
correct, Your Honor.
just a second.
Well, let me just pull up the text message since it's so
But you
accurate.
do know that Mr. Joyner was there.
Yes, ma'am.
Okay.
It was a group. They decided to do a group thing. This is right here it says, never mind, no one's
no, I
not
can
going to
read.
help me
He's done the
anymore.
Group chat.
And then there's an additional where he says again that I'm going to let Noah have a couple of days off.
Just a second. Mr. Hendrickson, so on the 29th, you indicated to Mr. Ricks that Noah, that would be you, is not going to be helping me anymore.
Yes.
Yes, and you want to tell me why?
Noah and I had...
No, look at me.
Noah and I had an argument at the painting job
Tell me about
we were arguing.
Tell me about the argument, sorry.
We were
When did you have
arguing
it?
about the detail that we were putting into our work. I walked in and Noah was paying a lot of attention to detail, and Chris told me that the job did not have to be perfect. He just wanted it to be
just
done.
Just a second. So Noah was trying to be careful.
Yes.
And you said you don't have to be so careful.
Yes, Your Honor.
Is that what it boils down to?
Yes, Your Honor.
And that was on the 29th.
Yes, correct.
So after that, he said he's not going to work for you anymore.
Correct.
Now, so I gather from that statement that since you were working there since the 23rd, you didn't feel as if you had to be so careful to detail.
That is...
I mean, that would follow from what you just said to me. If Noah wanted to be more careful to detail, you say, oh, no, you don't have to be so careful to detail. It doesn't have to be perfect, right? And goodbye, which is what this says. So I have to assume, conjure up in my mind, that if you don't have to, doesn't have to be perfect, doesn't have to be such a great job. It can be, as my great-grandmother used to say, there's a difference between a schmearer and a painter.
That's right.
Now, I don't know who would understand that except another Jewish grandmother. But you understand the connotation. You can smear paint. I have a 9-year-old granddaughter who can smear paint on a wall. But if I want something professionally done, I try to get a painter.
I told Chris I was not a professional.
Just a second. You see, that's my problem with Mr. Ricks. If you want something done right, get a man, not a boy. Tell me the worst thing he told you to do.
I don't know what you were wanting from me.
What I want you to do is to tell me what he told you about black mold. Don't make it up.
Defendant Christopher Ricks claims Noah Joyner and Harlan Hendrickson slandered his business on social media. Noah and Harlan say they were not paid for painting Christopher's apartment complex.
Now, if I wanted somebody to work on one of my cars, I would not get somebody off the street who was selling popcorn at a concession stand and say to them, by the way, my car over there needs a new battery. Now, would I take my car back to the same dealership? Maybe not, because they're very expensive. But would I find somebody who at least had a referral, a recommendation? I have a 20-unit apartment complex that was empty. You want to use it as a business. You don't hire 2 schmearers to go and take care of your property. But you have to, if you didn't like their work, fire them. And if their work was not complete and only 3 units were touched, which I don't think that they argue with. So far, that's correct, Mr. Hendrickson?
That is incorrect.
How many units did you
5.
paint? 5.
And I actually painted 7, but I didn't complete the last 2. I just did the trim in it.
So you completed 5 units out of 20.
Yes.
I'm giving him the benefit of the doubt. And you agreed to $3,000.
That's incorrect, Your Honor.
How much?
We did not have a meeting to talk about a payment until the 29th, and that was actually part of the reason that him and I were arguing. Chris and I and Noah met at a coffee shop, and we spoke about how much we would be getting paid. We agreed on a $3,000 price for the end of the month of July because Christopher was supposed to be going on a vacation until July 20th.
So the $3,000 was mentioned.
It was mentioned, and then he told me and Noah, Chris told me and Noah that on the 30th, he would pay us half of what he was going to be paying us.
Just a second. You were hired to paint 20 units.
Yes, Your Honor.
You painted 5, which is 1/4 of the $3,000.
Yes, ma'am.
Let's say those apartments were complete, not satisfactorily to him, but now you both agree that the $3,000 price was mentioned for the 20 units.
Yes.
It would be $750 if they did 5 units.
That's all, $750. That would be $750 if you completed only 1/4 of them. Okay. Did you pay them any money for painting, yes or no?
No.
Okay, good. So best case scenario for the painting is $750. And I haven't gotten to his counterclaim yet, but you have one more claim. And your claim is that Mr. Ricks vandalized your car by throwing paint on it.
Sure.
Tell me when that happened.
We woke up July 20th, 2020.
7:20. Where did you wake up?
At our house, our apartment. Hot Springs,
Okay,
Arkansas.
tell me what happened.
I woke up to my car being splattered with the same color paint that we were using in his apartments.
Okay, so your car had paint on it when you woke up. Did you see anybody do it?
No, ma'am.
Just let me take a look at the photograph. Okay. Did you file a police report?
Yes, ma'am.
I'd like to see it. Okay, so no one saw this, but you say that there is a video that you have. I assume, Mr. Ricks, unless you want to tell me that you did, in fact, throw paint primer on his car.
I absolutely did not.
Okay, and you did not see anybody throw paint primer on the car. But you say there was a video. Noah stated that he has video from his apartment complex pointing right at Noah's vehicle.
I think the police put that in there because they had interviewed.
So there is no video?
No, ma'am.
And you did not witness this?
No, ma'am.
And other than thinking that this paint primer was a result of actions and retaliation for something that you did, do you have any witness that saw him do that?
No, ma'am.
I have to see proof that the defendant had anything to do with this car.
Yes, ma'am.
Okay? Did you take the car in to be cleaned?
Yes, I cleaned it myself just to avoid further damage.
Yes.
But after I cleaned it, I took it to the auto body shop to see what the actual repairs
Okay,
were.
do you have pictures of it after you cleaned it?
After we cleaned it, it looked somewhat like this. And then we had to take it to the body
Okay,
shop.
They
buffed out the rest of it for us.
So what you're telling me is you took it to an auto body shop, and the auto body shop...
They helped clean up the rest of it, but they still took off our top coat.
Okay, very good. Well, you have no proof he did it. So far, he owes you $750.
May I interject that he doesn't even own that car?
I don't care. I'm not giving him any money for the car. There's no proof you did anything to the car. Okay, I'm not going to get into filing a false ABC complaint with the sheriff, because he's not going to be able to prove to me that it's true other than by what he says are his own observations. He doesn't have anybody here who's under the age of 21 who's going to testify that you served him alcohol. So I'm not going to entertain that part of your claim. Money owed for slander, that I would like to see. That's your cross complaint. So far, plaintiff has $750 for painting 1/4 of the places that he was contracted to do.
This is the first document, and I had calls just pour in, wanting to know if I'd seen it. And
Just
then,
a second. Don't tell me you had calls pouring in, sir, because that's
ma'am.
hearsay. What's the date on this? This one that I'm reading. It says 1 day ago.
It was around the first couple of weeks of July.
Okay. I'd like you to tell me, Mr. Joyner, the conversation, where it took place and under what circumstances, when you had a conversation with Mr. Ricks about covering up certain hazards. I'd like to hear that.
What would you like to hear?
I'd like to hear where the conversation took place, exactly what you said to him and what he said to you.
Where it took place?
Yes, where it took place, exactly what you said to him and exactly what he said to you.
I'm confused. So, like, what is?
We are on now.
I know the post about
a
the
post.
Yeah.
We're on now a post. So I want you to tell me when you had the conversation where you were and what you said to him, mostly what he said to you, about covering up certain things with paint.
Okay, yes, ma'am. So we were told to cover up holes and stuff with caulking and then paint over it. And then we were told that
Now look at me.
I was told to go declutter one of the units that had a bunch of old parquet tile, ceramic tiles piled high to the ceiling with old ceiling fans deteriorating.
That was the unit that was on site.
Right.
Go ahead.
Right.
And
so he told me that
I want you to tell me the worst thing he told you to do in the apartment complex. Tell me the worst thing he told you to do.
There was a lot of terrible...
No. Just stop and think of what is the worst thing he told you to do, the worst instruction he gave you.
Pretty much that I should just do it without the proper protective...
No, that's general, sir.
Okay.
I asked you specific. You posted something about him, about his apartment complex, about the work that you were doing, and I want you to tell me the worst thing he told you to make short shrift of or to cover up.
Water damage, black mold.
Okay, let's go to black mold. When did you have a discussion with him about black mold? Where were
He
you?
told me to declutter the apartment. So that would be Wednesday, June...
So there was one apartment that he told you to declutter. Okay, and that would be June what?
Monday, June 27th. I think that's what that...
Was he there in person?
Yes, ma'am.
Okay, so I'd like you to tell me what he said to you and what you said to him.
Told me to go...
Look here.
Told me to declutter the unit, take out all of it, throw it away, and to just...
No, don't look over there.
To clean, just to clean it, basically.
To clean it.
So that it would be ready to be painted.
And?
I did. I cleaned it.
And?
I'm done.
You done?
I don't know what else to say. That's...
Well, I want you to clean it. Doesn't tell me anything about black mold.
I don't know what you were wanting from me.
What I want you to do is to tell me what he told you about black mold. Don't make it up. Your post, based upon your testimony, was slanderous.
I got confused. I don't know what you were really trying to, ask out of me.
I asked you specific questions. You gave me answers. Now is not the time to play catch-up.
Defendant Christopher Ricks claims Noah Joyner and Harlan Hendrickson slandered his business on social media. Noah and Harlan say they were not paid for painting Christopher's apartment complex.
Now, tell me what he told you about black mold.
He didn't tell me anything about the black mold.
Great. And what did he tell you about rat feces?
Didn't tell me anything about rat feces. I handled all that stuff without me.
Shh. Then you did that all yourself. Well, in this posting you said, Chris, that would be you, wanted us to paint over chips, possible, dust, maybe, mold, never. He never told you that. That's what you just told me. Black mold, rat feces, and urine. He never told you to cover up those things. You may have done it, but according to you, he just said, clean it.
He had told me to cover up the mold that was in
I
the
don't
utility
believe that.
faucets of the apartment.
Oh, I don't believe that. In a second. That's Mr. Joyner.
Yeah, it was Mr.
No,
Joyner,
this is
but
Mr. Joyner's
trying to communicate
post.
together.
And he never told him anything. According to him, he said, just clean it. You have the second post?
That one was taken down, and this is the second post that he reposted, and then his account got blocked because they don't allow that type of behavior. This is the next one, and this is where he claimed to be a bartender on Facebook, and he just took it down recently. It's been up there for months, and I never hired him for a bartender.
That's all right. I don't care. That's not important.
Okay.
What I'm concerned about is what he says that you told him to do, which you did not.
Right.
He acknowledges you did not. Now, you have no witnesses here.
I was going to bring one person, and she's got COVID.
Shoulda, woulda, coulda. You have
yes,
no
I have
witnesses
no one.
here.
I have no one, Your Honor.
Very good. Okay. I find that the things that you posted are slanderous with regard to what he instructed you to do, Mr. Joyner. You were the posting person as far as covering up black mold, feces, and urine, and therefore to beware of Rick's Realty. Your post, based upon your testimony, was slanderous because he never told you that. So...
But you never really cleared that. I'm sorry. You never really cleared it up. I got confused. I don't know what you were really trying to ask out of me.
Yeah, just a second.
It was
I don't care
told
what...
to me that I needed to take care of all that stuff and throw it away. Yes, ma'am. It was told to me that. That's why I posted. It was a warning as to so no one else would have to deal with that same stuff.
Very good. Very good. I'm ruling now, so now it's my time. I asked you specific questions. You gave me answers. Now is not the time to play catch-up. I find that by posting that he instructed you to cover up black mold, people responded to, actually, and rat feces, I don't know how you cover rat feces and urine with paint, and to stay away from his place of business without cause, because what you told me was, he told me to clean it up, that's slanderous. And so on the counterclaim that he has for slander, I am awarding him $2,750. That's a net to him of $2,000 because your claim of $750 for wages is absorbed by his counterclaim. So on your claim, you get zero, zippity-doo-dah. I'm awarding him $2,000 for slander. We're done here. Thank you very much.
What about the damages,
We
Your
are
Honor?
finished. Hire a professional, Mr. Riggs. You want a schmearer? That's what you get.
This court is adjourned.
Regardless of terminology and how things got messed up, why would you expect someone to clean up rat feces, all of this stuff, and do it for free?
It's clear no good deed goes unpunished. I tried to help those kids.
Don't understand any of this, really.
Well, they were trying to extort money from me and not do work and be lazy and just get paid for work they didn't do.
We're trying to move on.
We're gonna move on.
You kind of try to give people chances when they're down on their luck. I've always been a philanthropist, try to help people out, and sometimes you get burned.
First of all, if you're an employee and you're working either by the hour or by the day, you're not a weekly employee or bi-weekly salaried employee, you're supposed to keep track of the hours where you work, especially if you want to, if there is a potential of suing later for them.
As a plaintiff, that is your burden. I was interested to see that you were willing to take that information from the defendant, because if it were me, if the plaintiff didn't have it, that's not the defendant's burden to prove the plaintiff's case. So I knew you did it to sort of round out the sides of the case, but I think that if you as the plaintiff want to come here and ask the court for money, you better have your ducks in a row. And
well, that's true. That was true. That was probably an error for me. Not that he got anything, but
we got where we needed to go.
We got where we needed to go, but that's true. It's not the defendant's burden.
Yeah.
Although the defendant acknowledged that he worked for him.
He did. Very forthcoming and honest. So, but that, again, played better for the defendant, as we saw in the ruling, that he was professional.
You're supposed to have your ducks in a row.
Yes, and as a plaintiff, you don't get any money if you can't even keep track of the hours that you work.
The second thing is that the call to alcohol and beverage, you know, if you feel as if you're doing a public service by reporting behavior that you think could be potentially dangerous, I support that. Mm-hmm. But if you're doing it as a retaliatory act and you don't do it immediately, it's like reporting suspected child abuse. Mm-hmm. If you see a child being abused or neglected and you do nothing and wait a month until you have a fight with the person who is the abuser, that creates a suspicion that it's vindictive and there's a motive to lie.
Of course.
Because it wasn't done immediately.
And they sought another job from the same man after reporting him.
Right. You know, to the defendant's detriment, in my eyes, is if you have a big apartment complex and you have guys who were in the jewelry business and didn't make it, then came to work for you in your theater and really weren't very good at that either, then I wouldn't hire them to house paint.
Yeah.
You know,
that actually requires a skill.
Without any credentials. So I think that you have to be careful if you have a valuable piece of real estate.
Agreed.
Anyway, he can't slander him, and he did.
I think it all worked out how it was supposed to.
I hope so.
Is suing his ex-girlfriend, Gigi Strackman, for a plane ticket, credit card charges, and a stolen cat.
Court come to order. All rise.
Have a seat, everyone.
Hello, Judge. Case number 2016, Pajaro versus Stratman.
Mr. Perari, it is your claim that the defendant, who lived with you for a brief period of time, owes you money for a plane ticket and for her unauthorized use of your credit card.
That's correct.
I don't know what the defense is to this, except that I think her defense is that you were just stupid and she took advantage of you. No. I'm trying to figure it out. I'm actually trying to figure it out. But you met the defendant, according to you, on an online dating app and started a conversation with her on what date?
So we met in March 2020 on a dating app for LGBTQ people. We started dating in March 2020. 4 months later, she moved in with me, which I know is not smart, but...
July?
Yes, in July 2020.
And where had she been living?
She had been living in Florida.
And where do you live?
I live in Seattle, Washington.
Did you send her money for a plane ticket? How did she get to you?
She had money herself at that time to cover the cost of moving.
So she moved and it was her own funds that she used to move?
Yeah, the swindling hadn't started yet.
You must have had some substantial What is this? What is this look? I don't know what this look is.
Oh, it's just the verbiage.
Okay, well, let me go back and let me start with you, okay? Because there's only one theatrical person here in this room, and that's me. Do you understand?
I do.
Yes. I get paid the big bucks to be theatrical. Okay, so Miss Strackman, you lived in Miami. He lived in Seattle, Washington. You decided to move in with him. What kind of work were you doing in Seattle?
I was a video editor, but when COVID happened, everyone kind of lost their jobs.
And what arrangements did you make with him when you were going to move in with him?
He told me that if I gave up my life in Florida, I had a very lovely apartment, lots of friends.
You had a lovely apartment, you had
I
nice
gave up
friends,
everything to
but
go
no
and
job.
move to Seattle.
Okay, so he said, move to Seattle and I'll take care of you.
Yes.
That's what you say in here.
Yes.
And that was in July of 2020.
Yes.
Is that about what you said to her?
No. The reason she moved in, again, it was 4 months after we started dating, which normally...
Had you seen her during those 4 months?
We had Zoom.
That's either yes or no.
No.
No, you had no
virtually.
physical
No.
contact with her?
No.
Okay.
But because we were in lockdown and we were both pretty isolated, it made sense. Her lease was ending and things moved really fast between us, so we decided to try it together. Yeah.
Okay. Was there any discussion about what she was going to do once she got to Seattle?
Yeah, so as she stated, she was a freelance video editor, and she said she was going to potentially have more work in Seattle and continue to try and find gigs for that or find other employment, drive for Uber Eats.
But she came to you and she wasn't working?
She wasn't working, no.
Okay. And the relationship with her ended in what month?
It ended in February 2021.
So it was a relatively short live-in period, maybe 6, 7 months.
Right, because of her.
Did she ever work when she was with you?
Not that I
Just a second, I'm going to ask her. Did you ever have full-time gainful employment during the time that you lived with the plaintiff?
I did not. I was not supposed to.
I didn't ask you. I don't ask to be editorialized. I asked you, did you ever work full-time?
No.
Did you ever work part-time?
No.
Okay. Then there came a time, according to what I read in both of your papers, that he purchased a plane ticket for you to go back to Miami. That would be a yes.
That is correct. You're right.
And what month was that?
That was in February of 2021.
And tell me, in your own words, what you told him as to why you wanted to go to Miami, because he wasn't going with you.
He was not going with me.
Tell me what you told him as to why you needed to go to Miami.
I told him that I needed to visit my sister.
And does your sister live in Miami?
Yes.
Had you been there to visit her before?
I had, yeah.
While you were living with him?
No. I didn't travel.
So this was the first time you wanted to go and visit your sister?
Yes.
Okay, was there any specific reason that you gave him as to why you wanted to go visit your sister?
She was sick and I wanted to be there.
But did you tell him what she was sick with?
Yeah, it was COVID.
Does she live alone?
At the time, yes.
You know, it's not going to be easy. It's going to get harder. Now, the plaintiff seems like a relatively intelligent human being. Hands off hips. If somebody I lived with say, I want to go and see, unless it was a young child, maybe in a school or something that lived alone in an attic dormer, I want to go see my sister who's sick with COVID, and you don't have COVID, and this is 2021, I would say, well, why would you do that and put yourself at risk and then come back and put me at risk? Didn't you have that conversation?
We didn't, Your Honor, no. It just didn't come up.
I want to go take care of my sister because she has COVID? What about isolation? Didn't you ever hear about that?
I did hear about that. I spent a lot of
Well, what do
time
you think that means?
Isolation means not traveling.
No, isolation means you're not supposed to be around other people if you test positive for COVID. If you're sick, stay at home. You don't travel cross country to be with somebody who's sick. But it doesn't make any difference, actually, because you should have picked up on that or whatever, because you didn't really want this ticket, according to what I read, Miss Strackman, to go and visit your sick sister. You needed this ticket because you had started to become involved with a boyfriend who was in jail in Florida.
Unfortunately, yes.
Okay. So that's a yes, which you didn't tell him. So you took the money from him for, let's just start with the ticket, under false pretenses.
I did, but
Just a second. That's all. I did. Not a but. Not a little. I did take the money from him under false pretenses when you went to Florida. He said you needed it for one thing, and in fact, you didn't. That's under false pretenses. How much was the ticket?
The ticket was for $427.40.
Okay. And when you went to Florida, Miss Strackman, and you stayed in a hotel, motel? What did you stay in?
I stayed in a hotel.
And whose charge account did you use for the hotel?
Yenny had given me a credit card.
That's not what I asked you. That's a name. Whose credit card did you use when you stayed at the hotel?
The plaintiff, Yenny's.
Mm-hmm. And that was by prearrangement with him that you were going to stay in a hotel rather than with your sister?
No, but I had the credit card for.
Now, that's not what I mean. Let's go back. You had the credit card. I'm assuming for the purpose of this question that what you say, and I don't know if it's true, but assuming for this question that what you say in your answer is accurate, that he gave you a credit card to use for your necessaries and expenses for emergencies.
Yes.
Yes. You would agree that going to visit secretly another boyfriend in Miami is not a necessity.
You would agree that Yenny cheating on me was not a necessity.
No. But did you use his credit card?
I did, and I believe that human love and kindness.
Okay, just a second. That's it. Do I look like I need help from you? If you had given him, Ms. Strackman, a credit card, I want you to try to take everything else from out of your mind. If you had given him your credit card and said, I'm giving this to you because I said to you I would take care of you when we lived together if you didn't have a job. Let's say I believe that. I'm not so sure, but let's say I believe that. You would agree that going to see another boyfriend across the country was not a necessity for him. Or for me, or for Whitney,
for you, no,
or
but
for Sarah.
For me, I'm a woman with needs. I need dopamine, I need love, I need connection, and I wasn't getting that from Yenny. So it was a necessity that I went to go visit another man. Yenny had other girls as well on the side.
But you didn't, just a second, Ms. Strackman, you didn't pay for the other girls. You didn't pay for his other girls.
I paid emotionally.
Oh, you said, what an idiot. What led you to believe you had the legal right to take that cat?
Because that cat had become severely bonded to me. Yenny was neglecting both of us, both of the women in his life he chose to neglect.
Tell me how the cat died in your custody. That's not a smile story. You always make a big deal, according to you, about your birthday. It's a very important day of the year.
Correct.
Yeah, that's the way Sarah feels, actually. Me, I sort of like to forget birthdays now. I like it to run right by that day as undercovered as possible.
Mm-hmm.
Yenny Pajaro claims his ex-girlfriend, Gigi Strackman, owes for the cost of a plane ticket, credit card charges, and stealing his cat. Gigi says they were all necessary expenses for her.
Now, you should feel so lucky that you got off so cheap.
I think you should assume everything that comes out of her mouth.
No. Yeah.
Because if I had, I wouldn't be here.
I get who I'm dealing with,
Yes.
sir. $427 for the flight ticket. How much was the credit card?
The credit card, also there's an incident with my cat as well, which
Just a second.
I'll address later.
Well, I'm going to get to that in a minute. That's your least strong suit, but it sort of tells me again who I'm dealing with.
Okay.
How much did she use on the credit card in Miami?
Okay.
Only in Miami.
Right. In Miami, she spent $1,000 on...
Now, just a second. Is that a sheet from your credit card company?
Yes.
I'd like to see it. Easier.
Would you like me to add the $427 for the flight ticket?
Yeah. Let's separate the two for me now.
Mm-hmm.
Okay. Giving me start. Just show me where the bills are.
So those are two separate credit card statements because she used it in 2 separate months. One of those is when she initially started using it, which was...
I don't care when she initially started. Let's understand.
Yeah.
She got your credit card.
Yes.
I only want to see the charges from Miami.
Okay. It's the one that says bail bonds, the bigger charge, which was...
Just circle.
Okay.
How much?
That was for $1,000, but overall it was...
No. $1,000. We're going to do it this way. $1,000 bail bonds.
Yes.
Okay. Next.
And then she spent $262.50 at a hotel for both of them.
$250 for a hotel.
And then she spent $105 on a fancy dinner for her and her lover.
And her what?
And her lover.
Okay. 150?
150 is not fancy. That's the kind of person you're dealing with.
150. I don't think there's a question before you, madam. 10, 4, $1,400 there. Is that close?
Including the 1,000?
Including the 1,000, but then not including the 425.
Yeah.
So it would be 1,827.
Correct.
Thank you. Okay. Now let's get to the final issue. So that takes care of your plane ticket and the credit card while she was in Miami. Now let's talk about the cat. Ms. Strackman, you moved in with the plaintiff July of 20.
Yes.
And when you moved in with the plaintiff, did he have a cat?
Yes, he did.
Okay. And what was that cat's name?
That cat's name was Momo.
And you lived with him a total of approximately 6 months.
Yes, Your Honor. And during that time, the cat.
No, I didn't ask you any questions. There's no question before you. There's no question before you. I have dates. You moved in, you lived with him for 6 months. When you moved in, the cat was there. And if you recall, in what month and year had you gotten the cat?
I got Momo right before she moved in with me as an emotional support animal, which is legally protected.
When you say right before she moved in with you, give me the month.
It was June,
and where did you get the cat from?
June 2020. I adopted her from a shelter.
So you didn't have the cat long?
No.
When she moved in?
No.
And then the two of you had the cat?
Yes.
Okay,
but
great.
The cat was
and then when she, just a second, then when she left in February of 2021.
Mm-hmm.
Okay. We are now in August of 2022, and you recently filed this case with regard to your cat.
Right. I didn't know where she was.
Just a second.
Disappeared.
I don't care.
Okay.
You recently filed this case with regard to the cat. Did you make a police report when she left with the cat?
I don't.
The answer is either yes or no.
I don't like involving the police, so no. I didn't want to ruin her life.
Oh, well, I want to tell you something. I have a small 4-pound dog at home. I love that creature more than anything in the world, except my grandchildren, my husband, and my children. Hope there are enough life rafts for everybody, including the dog.
I did try to hire a private investigator in Florida, but I didn't know where she was.
Okay, you didn't report it to the police, and I do have a problem with that. Now, Ms. Strackman, you knew when you moved into him he had this cat that he had adopted.
Yes, Your Honor.
I want you to tell me what led you to believe you had the legal right to take that cat?
Because that cat had become severely bonded to me. Yenny was neglecting both of us, both of the women in his life he chose to neglect.
Because I was working and
No, just a second. Don't.
Sorry, I paid for everything.
And so the cat.
So he was neglecting the cat and you, so you decided maybe half a neglect, you could be one whole person.
Exactly. Me and her are just getting out of here and gonna go start a new life together. I spent day and night with that cat. That cat was extremely bonded to me. She would be devastated without me.
Tell me how the cat died in your custody. Tell me how the cat died in your custody. That's not a smile story.
It's not. No, it's absolutely devastating. I am completely torn up about it. Unfortunately, my boyfriend's dog was not accustomed to cats and mistook her for a toy, and she did not survive that.
What kind of a dog does your boyfriend have?
We don't know the breed. I've never done the genetic testing.
You have a picture of the dog?
I do not. I didn't bring any evidence. So I was hoping you just used.
You just brought your smile. Okay.
She's not with her boyfriend.
She said, I didn't ask you a question. There's no question before you.
Love transcends bars, Annie.
Okay. 1827, $1,000 for taking his cat, and because you're a fool. 7, 2, 8, 2827. Judgment for the plaintiff. Thank you very much. We're done here.
This court is adjourned.
First of all, I'm glad, and I think justice was served. I'm not for Momo, but for the other scams that Jacqueline pulled.
Then I need dopamine, I need oxytocin, I need love, I need care.
Well, credit card fraud.
And Yenny said that they were going to be the person who was going to give that to me.
Deception, played with my heart.
And then didn't, so I had to find it elsewhere.
It was incredibly, this was Momo.
I did not have the cat killed. I was very attached to Momo. That was my cat as well.
It was incredibly hard to deal with. I was also alone when I had to process that news, so.
I did not set a hitman out on the cat. That's a lot to say.
She saw me as a sugar daddy, and she saw herself as a wannabe Anna Nicole Smith. Unfortunately, neither of us are those things.
Could I plead the fifth on finding another sugar daddy?
Yet another lesson we learned about cohabitants living together and the rules of what not to do. No cars, no pets, no money exchanges.
No joint pets, no joint.
Exactly. But today we learned a
shares.
new one. Today, don't give access to your credit card to anyone that you don't want racking up charges for any purpose, even to visit a secondary lover in another state.
You know, the divorce rate in this country is still hovering we're around 50%. The living togethers who don't quite make it to the marriage place is a much greater number.
Yeah.
Living togethers don't stay together 70% of the time. Why in the world would you buy a pet together?
It's a risk.
Car together? A timeshare together?
True.
Or give somebody a credit card.
Yeah.
At the time that you do it, you're happy with them. But since at least 70% of the time you're going to go your own separate ways, at that time you're mad at each other.
And the lines get blurry.
And the lines get blurry, absolutely.
Case number 2024, Morgan versus Davis. All parties, please step forward.
Corey Morgan. is suing dress designer Jacqueline Davis for party costs and a dress deposit.
Ms. Morgan, this is what this case is about in a nutshell. You were celebrating a birthday. When was your birthday?
March 24th.
And you always make a big deal, according to you, about your birthday. It's a very important day of the year for you and for everybody who knows you.
Correct.
Yeah, that's the way Sarah feels, actually. Me, I sort of like to forget birthdays now. I like it to run right by that day as undercovered as possible. Anyway, you celebrate your birthday with a big party.
Right.
And according to you, you get a spectacular dress for this party, invite everybody that you know and care about. How many people were you having for your birthday party?
It was going to be about 12 people.
Where was it going to be held?
It was going to be at the James Harden restaurant.
Who was going to be there?
My best friend from Chicago, my mom, my dad, just an intimate setting of family and friends.
Mom, dad, your best friend from Chicago. Who else?
Just family, cousins, aunt.
And you couldn't get the restaurant for that day, so you made it in April on a different day than your birthday.
Yes, I originally booked it in January 18th. The restaurant, it's a big deal, so yeah.
Whatever. It was postponed until what date?
Yes, ma'am, April 1st.
Okay. What about your best friend from Chicago? You told her not to come in because you didn't have a dress?
Well, I told him that I would be canceling the dinner because when she didn't deliver the dress, everything was already in black and silver.
Black and silver. You put on black pants, black top, and you put on silver around your neck. It'd be ridiculous, Miss Morgan. You have to grow up a little.
Corey Morgan says dress designer Jacqueline Davis is responsible for party costs and a dress deposit. Jacqueline is countersuing, claiming Corey owes for travel costs.
And you ordered your dress from the defendant. You found her through a mutual friend because she makes wonderful clothes. The defendant also is a tax preparer, I understand. Is that right?
Yes, ma'am.
So she's busy. So she makes clothes. She's a tax preparer in season. You made arrangements with her to make your dress, and she was going to make your dress at the cost of $300. According to you, you didn't get your dress in time. It was never fitted at all after your initial measurements were taken. Is that correct?
Yes.
And since you didn't have the dress for your dinner, you had a terrible birthday, you canceled your birthday, and you want her to pay for the dinner.
Yes. Just the build up.
That's Miss Morgan. How old are you?
I just made 35, so it was the build up leading to it.
So if you turn 35, I'm a lot older. Sarah's younger, and my other grandchildren, you know, were around that age. I have one that's close to your age. I cannot imagine any of my older grandchildren, or me, for instance, canceling an event because I didn't have just the right dress. I mean, it's not as if a bride is canceling her wedding because she didn't have a wedding dress to wear. Of course, if you want to get married badly enough, you put a sack over your head with a tie and you walk down the aisle. But you don't cancel the wedding. So you want her to pay for the deposit that you made on the dress.
Yeah, it was.
And another $1,000 or more because you didn't have a nice party.
So originally when I booked it, it was for April 1st. When I tried to rebook it because she told me at the last minute that she was not going to be able to do the dress, which was the week of. I had originally set up for her to do the dress so I could have something to wear. I purchased shoes, nails, everything.
I understand everything. She's not going to pay you for the party. You should have worn something else for the party. Believe me, your best friend from Chicago, your mother and your father would not have cared if you wore that dress or any other dress. You should not be out a penny.
I was out of penny.
Well, you were out $150. You gave her $150. Is that right?
Yes, Your Honor.
Okay.
I gave it back to her. I sent her a refund.
Oh, you did send her a refund?
Yes.
Did you? Just a second. Up. When did you send her a refund, Miss Davis?
I sent her a refund on March 29th. She requested a refund on March 28th, and I sent it directly to her.
To her on March 29th?
Yes.
How did you send it, by check or?
She sent me the money via Cash App, and I returned it via Cash App.
Do you have verification of that?
Yes, I do.
And she kept that money?
Yes.
Is that correct, Ms. Morgan?
Yes, ma'am.
That's
But
just a
leading
yes.
up to, yes.
Well, what did you think you were taking that money for? You asked for a refund, she gave you a refund.
I gave her $150 and she sent me $105 back, but she sent it the week of my event. So
I don't care, it was the week of your event. Did you send her 105 or?
I did.
Why?
Because I was charged a fee with Cash App, and also there were additional items that were purchased that I told her about that I deducted from that.
You can't deduct anything from that. And you can't even deduct the fee from Cash App because what it cost her was more than $150 then to send it to you, right?
Right.
Right. So why should you send her less?
Because I previously explained to her that I needed to order stones. Those stones were ordered.
Oh, then you're going to have to eat those. You didn't have the dress in time. You didn't have the dress in time.
The dress wasn't done.
No, it wasn't done. Not even according to you was it done. She hadn't had a fitting on it. The problem is you gave her money, and you should have sent her exactly what it is that she sent you because you didn't fulfill your end of the contract. A day before the party is not time to say it's 95% ready. Okay. She has to give you $145.88, which is exactly what she received. Am I correct that that's what she said?
That is what she said.
$145.88? Okay. She doesn't pay you for your disappointment, for your sorrow, for your party costs, or anything else, just for my own information, because that's my judgment. Did you spend your birthday with your mother and father? That's either yes or no.
No, ma'am.
Who did you spend your birthday with?
My boyfriend.
Oh, was he invited to the other party?
The dinner, yes, but I had to cancel the dinner.
No, I'm just asking.
Yes.
You didn't have to cancel the dinner because you didn't have a dress. That's what I'm trying to get to you. You could have gone to your dinner in that dress. I know, it's silly, and it's a little bit immature also. What about your best friend from Chicago? You told her not to come in because you didn't have a dress?
Well, I told him that I would be canceling the dinner because I purchased shoes, my nails, everything was accustomed to the dress. So when she didn't deliver the dress, everything was already in black and silver. I did not have a chance to go look for anything because it was the week of.
Oh, yes, of course you did. Of course you did, black and silver. You put on black pants, black top, and you put on silver around your neck. We're done here. Don't be ridiculous, Miss Morgan. You have to grow up a little. You have to give her back her money. Don't disappoint people. I mean, I know it's busy. It's tax time, you said to her. I'm busy. I'm working on things for the Oscars. You can't overstretch yourself. I know that it's very entrepreneurial to try to do too much. But sometimes when you try to do too much, you disappoint somebody.
This court is adjourned.
I'm not happy about it just because I'd already given her a refund.
I'm happy with the decision. It was pretty much principle for me. She was very unprofessional.
And given from the beginning, I worked with her.
And she didn't respect my time, and she canceled on me at the last minute.
And she waited to the last minute and canceled the order. So
she canceled at the last minute because she didn't have the dress ready to begin with.
Everything was really on her, but she put it on me because she was unhappy with how she chose to deal with the whole situation.
We'll be getting another dress with my original person that I was going to go to.
Absolutely not.
But from now on, I definitely will be going with who I know.
Will not work with the plaintiff again.
So I remember seeing through COVID, a lot of wedding dress shops closing down and the stress of brides going for fittings and seeing their dress, picking their dress, and then the shop just closed right out from under them. I wonder if any of them canceled their wedding because they didn't have the right dress.
I think that one of the life's lessons is as you get older, you have to prioritize the importance of things.
True. Spending time with friends, family, out of town, coming for your birthday. I couldn't imagine canceling an event just
because you didn't have the right
outfit.
dress. Because you didn't have the right dress. So I think that there's a lot of growing up to do, maybe a little less narcissism, because it would seem to me spending time with your boyfriend, your mother, your father, your best friend from Chicago is more important than having the right dress to fit your nails and your shoes.
I agree.
Maybe I'm just...
is suing her ex-roommate, Adrian Carter, for property damage, breaking a lease, and a dog attack.
Court coming to order. All rise.
Be seated, everyone.
Hello, Judge. Case 2080, Baptiste versus Carter.
Thank you.
You're welcome.
Miss Baptiste, you and Miss Carter were roommates.
Yes, ma'am.
From when to when?
From October 7th to April 1st. Actually, May.
And it is your claim that Miss Carter vandalized certain property of yours.
Yes, Your Honor.
Most specifically, a very expensive couch.
Yes, Your Honor.
Because you had an argument, and that during the course of this argument, her dog bit you?
Yes, Your Honor.
And for breaching the lease, because she left.
Yes, ma'am.
Okay, but it was a good thing that she left, right?
Yes, ma'am.
You were happy that she left. Her dog bit you. She vandalized
Right,
the sofa. You were very
I was
happy
very
that
happy she left, yeah.
You were very happy. So we're going to eliminate that breach of the lease part.
No.
Oh yes, we're going to eliminate the breach of the lease part because you were happy that she left.
I didn't want her to live in the same situation as her, but being that the rent was so expensive, it wouldn't have been my best interest for her to leave.
It's with her to stay with her dog that bit you.
Right.
I mean, I don't want you to sound ridiculous to me, okay?
Right.
All right, let's not sound ridiculous to me. Normal person, if they were bitten by their roommate's dog, and if their roommate vandalized their property, that roommate would be happy to see them go.
But I'm not happy with the expensive rent by myself.
Well, of course, but your choice would be staying with her and her dog that bit you.
But if her name's on the lease...
Just a second. That's between her and the landlord. I just told you, I'm sticking with vandalizing and dog bite. So tell me when this dog bite took place.
It's on March 29th.
What kind of dog was it, by the way?
It was a Belgian Malinois.
What do they look like?
It looks like a German Shepherd.
Is that what you have, Miss Carter? A Belgian
Yes, Your Honor. Yes, Your Honor. A Belgian Malinois, like a police dog.
So it looks like a German Shepherd?
Yes, ma'am.
So it's a large dog?
Yes, ma'am.
And when you moved in together, you moved in with the dog?
Yes, Your Honor.
Okay. So tell me what happened March 29th.
Okay, so before March 29th, Adrian and I got in a petty argument. It was dumb. We made up. In the argument, she confessed to me that...
No, just a minute. You engaged in a petty argument, and then you made up.
Yes.
And the petty argument was on what date?
It was on the March 27th.
And you made up?
Yes.
Okay. On the 27th, what were you arguing about?
My dog tore up the carpet, and she sent this long paragraph, and we were just going back and forth, and we realized it was dumb, so we decided to drop it. And that's when she confessed to...
On the 27th?
Yes, ma'am.
So you were arguing about the dog, and then on the 27th, after you were over the argument about the dog, is that what you're telling me? Be very careful.
Yes, ma'am.
Go ahead.
She confessed that she gave the guy that I was seeing a lap dance.
And?
And I immediately cut all ties with her.
So you cut all ties with her how?
I stopped speaking to her.
Even though you were roommates?
Yes.
Okay.
After I stopped talking to her, social media posts were made.
By whom?
Adrian.
Okay. Social media posts were made. Do you have those?
No, I do not.
Do you have those?
Yes, Your Honor.
Okay. Why don't you have them if this is your case?
They erased, but I have other things that I think you would want to see.
I'm going in order. This is a case, so don't try to creep into my mind. Even say in your complaint a couple of days later, there were things posted on social media. And is what you're telling me that they were erased?
Right. I didn't save anything that she posted.
Oh, never mind. I don't have to see anything, correct?
Correct.
So you didn't save anything?
No, ma'am.
Then you have no evidence of anything that happened
So
later.
I saw that she had no remorse for what she did. Then I made social media posts. Adrian was mad that I made social media posts. So the next morning, she's yelling at the top of her lungs at 10 in the morning. I wake up to see what she's yelling about. And she's just saying how I'm a... and I shouldn't have posted what I posted. And we were just arguing about the situation. And I asked, how could she do this to me? It was a very heated argument. She was yelling at the top of her lungs. I was yelling at the top of my lungs. During the argument, her dog is going crazy. And while we were arguing, we were pretty close. The dog bit me, and I said, you need to get your dog. She said, no, your dog's good. And we continued to argue. The dog came to bite me again, and that's when I grabbed what was behind me, which was a paper towel holder, and I chucked it at the dog.
So the dog bit you on the arm?
Yes, ma'am, twice.
Okay. I would like to see a medical report on that.
Okay. All right, I have a photo of the bite, the antibiotics, and then this is the report.
Would you show this to Ms. Carter, please?
Your Honor, I know she has a video of the entire incident, if you'd rather.
It's not her obligation to prove your case, as my law clerk so aptly told me in the last case. Not her obligation, it's your obligation. Okay. So, go ahead.
After her dog bit me, I immediately grabbed my dog and I go to the hospital. I filled out
What kind of dog do you have?
I have a Doberman.
Where was your Doberman when this was going on?
He was in the cage, and he's still a baby as well. So I went to the hospital, got treated. While I was at the hospital, Adrian called the police, and she said that I attacked her dog.
Don't tell me what she said to the police unless you have a police report.
Yes, ma'am, I have a police report.
Then I'd like to see the police report. That's an official business record.
So this is the first police report for the dog bite.
Okay, go ahead.
All right, so April 19th, this day, Adrian knocked on my door.
No, April 19th? Where did April 19th? I thought you moved out on April 1st.
No, she moved out on April 19th.
So is what you're saying after all this altercation, she moved out?
Yes, ma'am.
And stayed in the apartment with her dog from the 29th to April 19th?
Yes, ma'am. And I went to a friend's house the day the dog bit me, and then I went home for a week, and then that's when I came back, and this second incident happened.
So after the dog bit you, you did not go home. You took your dog and left.
Yes, ma'am.
And stayed at whose house for a week?
I stayed at a friend that lives an hour away from my current apartment.
On what date did you return?
So I stayed one night at a friend's house, and then I returned, and then I went home for a week. So
when you went, stop playing with papers.
Yes, Your Honor.
When you went home for the day, was the defendant at home?
Yes, ma'am.
Did you have any conversations with her?
No, ma'am.
Just stayed out of her way and packed a few things and left?
Yes, ma'am.
And you went to stay?
At home in Alabama.
With your family?
Yes, ma'am. Until things cooled down, basically.
Okay, and when did you go back?
I went back, I believe, April 17th.
And what happened when you went back on the 17th?
A few days later, April 19th, Adrian was knocking on my door at 9 a.m. in the morning saying that I need to come to the leasing office because there's a new roommate here. I told her no, and then that's when she started threatening me and calling me all these kinds of names. So I take my dog again, I go outside, and I call an officer, and that's also when I called my mom, and she convinced me to go up there to speak with the new roommate to see, who they were.
What new roommates? Just a second.
She tried to get 2 young girls to replace her on the lease.
And it was unsatisfactory?
Yes, ma'am.
So far, I have a dog bite and
yes, ma'am.
Couch.
So after I said no to the 2 roommates, one didn't have a job, they looked young, I said no. I went back home. 10 minutes later, Adrian...
Home? You mean to your folks'
To our
house?
apartment.
Oh, to your apartment.
Yes, ma'am.
Okay.
So 10 minutes later, Adrian comes in. I was in the room with my door locked. I hear Adrian yelling. I hear her throwing things. She's saying, I can't believe you did that. You really just did that. I don't care. I'm still moving out. I'm still leaving. I'm not paying rent. Blah, blah, blah. I didn't come out the room because last time it got crazy, so I just said I would let her do what she does, and I will let the authorities handle it.
She did come out the room, Your Honor.
When I finally came out the room, which I have a video, and it came out, she had moved the couch in front of the door so I couldn't get out of my room. And
well, how did you get out?
I jumped over it. And the trash can was flipped upside down. I have pictures of all the damage that she did to the house and videos.
Well, I'd like to see them, please. And I would like to see the damage to the couch, which is your major complaint.
Yeah. Okay, so this is the damages, and then I have a video of the entire incident right here.
Want to tell me how that happened?
I did put chips and items that wasn't wet on the couch out of anger. I shouldn't have did it, but I did do it. And I didn't put liquid on it or anything. Literally,
That's not true, Your Honor.
Don't speak. You had no right to even attempt to destroy it.
At all.
Later.
So at that moment, I was like, you know what? I'll just do it myself so we can stop the confrontation. So then that's when the argument started, and he thought that I was kicking him out, which I never told him he couldn't come over, never told him he couldn't be a part of anything.
It's a failed business venture where you both expect.
It's not a business venture.
This is not a tea dance.
Brooke Batiste claims her ex-roommate, Adrian Carter, owes for couch damage and a dog attack.
By the way, did you have any unreimbursed medical bills as a result of this dog bite? That's either a yes or a no.
No, ma'am.
When did you purchase this couch?
I purchased it the day we moved in, so it was October 7th.
How much did you pay for it?
I paid $2,200 in total, and Adrian and I were paying on it a little bit in the beginning, but there came a time where we had to make the final payment on it, which was $1,200. When we had the argument, she didn't pay anything, so I had to pay it all by myself. And the couch is in my name.
Did the couch remain?
Yes, ma'am. The couch is at the house.
What does it look like now?
It's black, but there's it's an odor coming from the couch, and there's some stains on it.
Do you have a picture of it, what it looks like now?
No, ma'am. I just have the pictures that I gave you.
Okay, but you're still using the sofa.
The
answer
is
is
a smell. No, ma'am. I don't sit on it anymore because it's a smell.
So why don't you get rid of it out of the apartment?
I'm moving October 6th, and that's when I plan to get rid of it.
But you've been using it since April.
It's just been sitting there, Your Honor. I haven't had
sitting
time.
in your apartment since April.
Yes, ma'am.
April, May.
I just haven't made the time to get rid of it because I know I'm moving soon, and that's when I plan to get rid of it.
I wouldn't keep something in my house that smelled.
I work a lot, and
Would you please show this to the defendant? Want to tell me how that happened?
I did put chips and like items that wasn't wet on the couch out of anger. I shouldn't have did it, but I did do it. And I didn't put liquid on it or anything. Literally,
That's not true, Your Honor.
Don't speak.
You can
No.
get a napkin and wipe it off. But that's my couch too. Maybe I didn't pay the whole thing on it, but I've made payments on that couch, and I decided not to do that full payment that she did, which was $600, because she was irresponsible and decided to rent a couch and found out that that couch was whatever amount. I made payments on that couch, and I have proof for it.
That's okay. You had no right to even attempt to destroy it.
At all.
At all. You had no right to do that.
Right.
Because that devalued the sofa.
I agree.
Okay, good. Okay. I'm actually finished with you.
Your Honor, can we please go back over the lease portion of this?
No.
Can my mom speak about what happened?
No, I said no. When there's that kind of acrimony, I actually think that before somebody gets seriously injured, when you have two large dogs and two people with hot tempers that can do this, it's a very, very good thing that they no longer live together.
Being stuck with a rent and
Just a second. I've just answered you. This is not a back and forth.
Yes, ma'am.
On the dog bite, I am awarding you $1,000. It looks as if part of it was a black and blue mark. Certainly, I can't blame the dog for trying to protect its owner, but she's supposed to have control of her dog all the time.
And she shouldn't start arguing.
This is not a tea dance. I'm not asking you anything. And I'm awarding you $1,200 for the sofa. That's $2,200. Judgment for the plaintiff. We're finished. Thank you very much.
Court is adjourned.
She just did something messed up, and I cut her off, and she didn't like it.
I literally cut her off. She's just mad that she's cut off.
She's delusional. She's delusional.
She's childish, she's irresponsible, and I was just sick of dealing with someone draining.
Just don't get roommates with your friends. Just move in by yourself.
I'm happy.
You had a question about the lease.
I did. So I agree that it was best for the acrimonious situation for them to separate and not to live there. So I understand your judgment saying it was better for you. You got the good end of the stick on that she left. However, the law, if you breach a lease, she did get stuck with a higher portion of rent because her roommate, although a negative situation that should have probably ended right when it did, she was stuck paying her half as well. So I thought you should have at least heard her claim on the breach of a lease, because then anyone could just say, oh, well, I don't like the situation and I feel like leaving would be a better thing, and stick their roommate with their portion of the rent. And that's not what the law says.
Well, that's true, except that this wasn't just a situation where parties weren't getting along.
Mm-hmm.
There's no question that she was nipped by the defendant's dog. Well, I wouldn't want to stay in that situation anyway.
Well, that would give her the right to maybe leave without paying her half of the rent, but that's not what happened.
It's also sort of acknowledged that the defendant brought two other people to take over her piece of rent. And it was in the papers, and the plaintiff did not...
She did say that she was the one that said no.
She said, I don't want those two people. Well, then the onus really falls on her to mitigate her damages. And she had no proof that she went forward to try to get another roommate. Between the two of them, they may have had an agreement, but the dispute over rent really is the defendants and the landlords. She doesn't pay her rent, and if the plaintiff pays her half of the rent, the landlord is free to go against either or both of them.
Sure, because both their names were on
Right, in the lease.
Understood.
Case 2083, David versus Baroon. All parties, please step forward.
Joseph David is suing his former friend, Jonathan Borum, for podcast equipment.
Mr. David, Your claim that the defendant has acoustical equipment that you purchased for what looks to be a joint venture in Mr. Borum's music podcast.
Yes, ma'am.
You were making this music podcast in the basement of your house?
Yes, Your Honor.
Starting in what year?
This year of March.
And Mr. David, you were friends, you knew each other, and you knew he was in this business. I don't know, what is your business?
I deliver bread. I'm a bread vendor.
What kind of interest do you have in music? Because that's what he was doing.
Well, me and Jonathan have known each other for 20 years.
Jonathan and I have known each other.
Jonathan and I have known each other for 20 years, and he's always been in the music scene. He's an artist himself.
Well, that's what I gather. What about you?
I was just a supportive friend in it.
Okay, well, clearly you spent some money on music equipment, so it was more than being a supportive friend. If you were just being a supportive friend, then you made a gift to him of this music equipment.
No, ma'am.
You decided you wanted to be part of this music podcast. That's what you said.
Correct.
When did you make that decision?
Sometime mid-June after I had...
June of this year?
This year, correct. I had received a small amount of money, and I was able to...
From where?
A settlement from
From what?
an injury, car accident.
Okay, how much did you receive?
A little under 50 grand. And I seen an opportunity for me to invest and help out and help a friend and be able to invest into something that if we blew up one day, I could receive, royalties from and money back in return. And
did you have a written agreement with him?
We did not have a written agreement.
Well, I'd like to know what the agreement was.
So he was also in the car accident with me as well. And so he's got a settlement coming. He told me, this was all verbal, that once he received that money, he would pay me back at least half of the equipment.
So you would have a joint venture and he would pay you for half the equipment you purchased?
This was at the beginning, correct.
Do you remember, Mr. Borum, that conversation?
No, ma'am, Your Honor.
Were you in the automobile accident with him?
Yes, ma'am, Your Honor.
You did not receive a settlement. Is there any reason?
We're still going through the court process.
Okay, so you're going to trial.
Actually, that's what it was set to go to trial because I didn't get the offer that my lawyer put in. So it's going to trial on my side, but on his behalf.
No, he's already settled his case.
Yeah, mine's not settled yet.
Okay. You indicate what you want is your equipment back.
No, I'd like the money back.
No, well, you get your equipment back if it's yours.
I want the money. I don't trust that he will give me the equipment back in good condition.
Let me explain this to you, Mr. David. If that's what you want, then I'm going to let you withdraw this case and go back to small claims court. Do you understand what I'm saying to you? I'm going to dismiss your case without prejudice, which will allow you to go back to your small claims court, or do you wish to proceed with it today?
I wish to proceed.
Great. Why did you say, I'll do the editing myself?
Because he was yelling at me and I told him...
What was he yelling at you?
Because he said that the product wasn't up to par. He said...
Just a second, Mr. Borum, this is your business.
Right.
Will you tell me, did you think the product was up to par?
Joseph David claims his former friend, Jonathan Borum, is wrongfully keeping his podcast equipment.
So, when you decided to enter this, according to you, agreement, that you would be in a joint venture, when he got his money, he would pay in his half of what the equipment costs, which you indicate, I think, is about $4,400.
Correct.
What I gather is there was a session set up that was supposed to take place in your basement.
Yes, ma'am.
And when was that?
I believe it was around like early June-ish.
Okay. And you have proof of the value of the equipment, I assume, and exactly what equipment there is.
Correct.
Is there, Mr. Borum, a dispute about what equipment he purchased?
Is there a dispute? Yes,
Yes,
ma'am.
because he has a receipt. I just want to know if I have to go into this.
Well, on the receipt, he purchased it on his card, but we're friends. We were going in together, so he bought it on his card because he had the money.
Oh, just a second. I understand that, Mr. Borum. I'm asking you whether there is an agreement as to what the pieces he purchased on his card.
Yes, ma'am. As far as the agreement, I'm not understanding the question.
Okay. What pieces of equipment did he buy that's in your basement?
Cameras.
Camera.
Cords.
Cord.
And probably the Black Magic.
Black Magic?
Black Magic, yes, ma'am. It's a device that works.
Do you know what he's talking about?
I do.
Anything else that's down there that you purchased other than those 3 items?
Yes, ma'am. In total...
What? Shh. Look at me. Tell me what else.
In total, there's 2 Panasonic cameras.
Are there 2 cameras that he purchased? 2 cameras.
Can I look down for...
I can't hear you if you're mumbling.
There's lighting, 3 lights. There's
3 lights. Did he purchase 3 lights?
Yes, ma'am.
Okay.
wireless mics.
How many?
It was a set of 2.
Did he purchase those?
Yes, ma'am. And not to correct you, but we purchased those.
No, you didn't pay for it.
I gave him the money. I gave him cash.
Oh, you did? You're going to show me proof of that in a moment.
Well, I don't have proof that I gave him cash. No, ma'am. Because we were friends, so.
Just a second.
Okay.
You have no proof? Did he give you cash?
No, ma'am. He never gave me $1.
Fine.
Not a penny.
Okay,
not a
let's
dime.
go. We have 3 lights, 2 mics. What else?
HDMI cord.
He has a cord.
Blackmagic ATEM.
He has that.
256 gigabyte SD card.
What is that?
Memory card.
It's a $50 memory card. It adds up.
Let's go.
The card reader, 20-foot cables, a stencil, and a table.
Just a second. A stencil and a table. Describe that.
It's for the logo that we made for the podcast. I purchased the stencil for the logo.
How much did you pay for that?
Between that and the table is $80.
Let's stay with the big ticket items, sir, Henry.
Adding
Great.
everything.
Okay. Are we finished with the list?
Yep, that's all.
Very good. How much did you pay for these things minus the $50 card in total? Show me.
Minus the $50.
Yeah.
$43.50.
Okay. And all of that is in your basement now?
Yes, ma'am.
Okay. And what happened, according to what I read, there was a music session scheduled. And at the time that there was a music session scheduled, your daughter had COVID.
Yes, ma'am.
She lives on top of the house. Okay. And how old is she?
That was in July. She's 10 months now, so probably about 8 months.
Okay. And she's cared for by both you and your wife. Is that correct?
Yes, ma'am.
And I gather, Mr. David, that when you found out that there was COVID in the house, you didn't want to go into the basement.
Correct.
And that was sometime in June.
Correct.
Okay, can you tell me about that conversation?
Well, he told me that she had COVID, and then he said that his fiance may possibly have it, and he may possibly have it. He even took off work, and I filled in for him at work for 3 days because he may have had COVID or not, and he said he wasn't
Well, he
feeling
wasn't. He didn't want to go in and risk it.
Correct. So I told him I do not want to continue with this interview. He said he would continue on.
You mean
with
the interview that was supposed to take place in the
Correct.
basement?
Correct.
How much after, Mr. David, did you find out that the infant had COVID and that Mr. Borum and his wife were both exposed? Was the video podcast supposed to be made in the basement?
2-3 days.
Is that correct, Mr. Borum?
From anywhere between 2 to 5 days, ma'am.
And when Mr. David told you he didn't feel comfortable coming into the house, what did you say to him?
I said, okay, I would have someone else fill in his position because I understood why he didn't want to come over.
Okay, and did you have someone fill in his position?
Yes, ma'am.
And then what happened, Mr. Borum?
The episode got done, and it wasn't up to par with Joseph's standards. So that's when the argument begun.
Okay, and the argument was what?
The argument was the guy didn't do it right, so it was a lot of bickering. So I told Joe, I just do the editing myself. And he took that as I was cutting him out.
Okay, so he was supposed to do the editing.
Yes, ma'am.
Okay, and why did you say, I'll do the editing myself?
Because he was yelling at me, and I told him...
What was he yelling at you about?
Because he said that the product wasn't up to par. He said...
Just a second, Mr. Borum, this is your business.
Right.
Will you tell me, did you think the product was up to par?
I did, but I thought it was up to par, but I took his recommendation because I brought him in for production. So I was like, okay, if you don't feel like it's up to par, let's figure it out. But then we kept going back and forth. So at that moment, I was like, you know what? I'll just do it myself so we can stop the confrontation. Because you didn't want to tell the guy what he did wrong. So then that's when the argument started, and he thought that I was kicking him out, which I never told him he couldn't come over, never told him he couldn't be a part of anything. I just told him I wasn't going back and forth because that's why I brought you in for that.
May I see the credit card statement from the purchase of this equipment? And Mr. Borum, I want to see where you took out $2,200 from in cash. I want to see where you took. You said you paid him half.
$2,200. I didn't pay half.
Well, what'd you pay?
I never stated that I
Just
paid half.
shh. If you're partners, that's what you have to pay. How much did you give him?
I gave him money here and there, like on all the...
That doesn't help. That doesn't help me, sir. That doesn't help me. These are bank statements.
I didn't think I had to keep a record if we was best friends for 15 years. That's just...
I can't help you, sir. I can't help you if you say you paid a little bit here and there. I can't help you with that.
Never gave me a dime.
So when you state that if you're a friend, you're doing this to help me out as a gift for what I got going on.
Never a gift.
And then you try to bring it and take it back from me.
Mr. Borum, how many podcasts have you made since June?
Since June?
Yeah.
I believe we on episode 15, 16, something like that.
15, 16. Successfully.
Yes, ma'am.
And you intend to do this for profit?
Yes, ma'am.
Have you so far seen any profit?
Not as now, because you gotta build up.
Just a second. So not as of yet.
Yes, ma'am.
Do you work?
Yes, ma'am.
Does your wife work?
Yes, ma'am.
Okay, so you have two incomes in the house.
Right.
And this is a side job for you.
Correct.
But you have to buy your own equipment because he's coming to get his equipment. That's going to be the court's order.
So if
it's
I
his equipment.
It's
his equipment. The equipment
so he
that
gift it to me. That's what he told me he was doing because we was friends, and he appreciated what I was doing.
This is why we're here.
Right.
And now I heard you, and I heard him, and now I'm ruling. I am making an order that he, within 5 days of today, with a marshal or a sheriff, will come and pick up his equipment.
So you giving him my equipment back is tarnishing what I got going on.
I'm giving him his equipment back.
But he never used it, though.
I don't care whether he used it or not. It was a failed business venture where you both expect.
It's not a business venture.
This is not a tea dance. He's getting back his equipment. You and your wife have a side business going. Go buy equipment. Do you understand? 5 days, wait outside. You'll get a copy of my order. You can go get your equipment. Thank you very much.
This court is adjourned.
A 15-year friendship, obviously it don't matter. You know what I'm saying?
Eventually, you see the real person in somebody. That's all I can say.
You could be friends with somebody 100 years, and they gonna change.
Yeah, I mean, I thought I had a good friend for a while, but really...
Man, the show gonna go on, man. Y'all know, make sure y'all watch, tune in.
I was just tolerating a really bad person.
I've had understandings with my friends similar to what the plaintiff and defendant has. One of my friends will stay in my apartment from time to time for a few nights, and I always make sure, because you never want a holdover tenant or a friend staying longer than you had anticipated, and I'll text and I'll say, okay, you're good to stay there Thursday and Friday night. Let me know if there's any problems, but you got to be gone by 9 a.m. on Saturday. Just to memorialize the understanding that I think I have, even with friends. It's just always smart to have some sort of record of a business, an understanding, a trade-off. I just think that it's good practice to, even if it's just a text, something to memorialize what you believe the understanding to be.
I agree with you. Yeah. And that would make my job easy, but would eliminate this TV program.
Potentially.
Potentially.
18-year-old Bella North and her mother, Angela North, are suing business owner Heather Olson for car damage.
Court come to order. All rise.
Have a seat, please.
Hello, Judge. Case 2092, North versus Olson.
Thank you.
You're welcome.
Ms. North, this is your daughter.
Yes, ma'am.
Why don't you have a seat? Because you actually weren't involved nor a witness to the incident. Are you the owner of the car?
No, ma'am.
Okay, why don't you have a seat? Tell me your first name.
Bella.
Bella. Bella, from what I gather from reading the papers, you and the defendant's daughter were good friends.
Yes, still are.
And have been friends for a very long time. So, not a very difficult case. You were going to visit Miss Olson's daughter, Lotus.
Yep.
And according to you, you've done that innumerable times in the past. You were also 17 at the time?
Yes.
You went to visit Lotus. I'm trying to find the date in your complaint. On April 16th of 2022.
Yes.
And when you got to the house, which you had done many, many times before, according to you, you parked behind the defendant's car.
Yes, I did.
Was the defendant in her car at the time you parked your car?
I did not see the car on when I pulled up behind it. I turned around for a moment to gather my things, to my backpack, my charger, everything. I then look up and I see the car is on. I never saw anyone. You
never saw anyone get in the car?
Yes, exactly.
Okay. Now, could you tell me what kind of car were you driving?
A 2001 Honda Accord.
So a very small car?
Yes, sedan.
And you were in a large car, Miss Olson? Your car is a large car.
Yes, Your Honor.
What kind of car is it?
It's a Suburban.
Now, can you tell me why you parked behind her car? If you parked behind her car, you were blocking her in.
Yes. So I parked behind her car because Lotus has told me in the past.
You can't tell me anything that Lotus told you.
Okay. I parked behind her car so that the driveway to my left was free for people to come in and out, because I am aware that she does have residents in her home, and I was...
But that means that she couldn't get her car out if you were parked right behind her.
Correct.
Okay. Now, is there parking on the street, Mrs. Olson?
Yes, Your Honor.
May I see that? No, I don't want to. Thank you.
May I describe what is in the photo?
Well, I'm just asking you, is there on-street parking here or not?
It's not laid out, but you're allowed to park on the street. We have also additional parking next door at the neighbors. They've invited us to park.
No, you can't tell me that they invited you. Sorry. I'm just asking whether Miss North could have parked someplace else. And the answer is she could have. It was more convenient to park behind your Suburban. Now, as you turned around to gather your backpack, according to your complaint, you felt something hit your car, your 21-year-old car, right?
Yes.
Would you look up 2001 Honda? Where did you get the car from?
I got it from a small dealership in my town, Sarasota.
Who purchased it?
I did.
For how much?
$3,000.
Okay. And you felt something hit your car?
Yes.
And then you looked up, according to what I read, and you saw the backup lights on.
Yes, I looked up, saw the reverse lights on, waited, saw the car back up into me, hit my car, I honk, the car stops, the car then continues to reverse again, hitting my car, I honk, they stop, I then turn back on my car, I reverse away so she can get out, and then she proceeds to leave.
Okay. And show me what the damage was to your car.
Yes, ma'am.
The Kelly Blue Book value is $2,500 to $3,500, so right in the range.
Great. What is this? A picture of?
The 2 scratches and the dent.
Let me see the whole car.
I do not have a picture of my whole car.
Well, that's unfortunate. I see a scratch. I don't know if it's a scratch. I see some.
There's a hole towards the corner of the light that was not there before. My whole light is.
You mean this?
Mm-hmm. Yep. See where there's a gap in the light is supposed to be collided with the bumper, and it's not.
Mm-hmm.
It was hit and damaged.
Okay. Did you see her car when you came out?
No, Your Honor.
She didn't see you, so you were in the car, I assume, when she pulled up behind you. Do you understand? So she was in her car, in her driveway, when you pulled up in your car and blocked her car in. If you had seen her in the car, would you have parked behind her?
No.
So you didn't look to see whether she was in her car?
No.
And she was in her car, and her car is high. You look up, you have a big Suburban. You don't expect anybody to be stupid enough to park behind your car. You're in your car already, because clearly she didn't see you pull up because she was in her car, right? Now I'm going to ask you, because you say you don't remember hitting something or you weren't sure you hit anything. Is that your answer that I'm getting?
When my other daughter drove up, parked the vehicle, left it running, ran inside the house, I ran out and, of course, checked behind me and drove out.
No. I asked you a question. You didn't?
I did not hit anything.
Well, you don't remember hitting anything.
Correct, Your Honor.
Yeah, because I don't think Miss North would have made up this story. You had a big car, backed out, and you drove away. Did you see her car pull off when you backed out?
No, Your Honor.
You did not?
No, Your Honor.
When she pulled out, did she go in the same direction as you did or the opposite direction?
The same direction.
Okay. Did you see her car after you pulled out?
No, Your Honor. Not until 2 hours later when we met.
Tell me what happened 2 hours later.
After returning from my appointment, I met Bella at the next door neighbors where we parked, and that's when we examined each other's vehicles.
Well, did she call you? How did you find out that there was an accusation that you had hit her car?
Because we met at the designating parking spots that we've agreed to park at.
So there was just serendipitous that you met there at the same time, or had you been in communication, either with her or your daughter?
I was at a brief appointment, and when I returned home, that's where I parked. And Bella also parked there because that is where we
Okay, so when you moved your car after the defendant, according to you, hit your car, did you park in another spot?
Yes.
Did you park in the neighbor's spot?
I did.
Okay, so that would indicate to me that you were aware that you were supposed to, or could, if there were other cars in it, park in the neighbor's spot, because otherwise I wouldn't park in a neighbor's house. So you were aware you could park there.
I'm never sure when the neighbors are home or not, and I don't feel comfortable parking at a neighbor's house.
But you did park in the neighbor's spot after this happened on April 16th. You did not pull back into Miss Olson's driveway. You pulled into the neighbor's spot.
I did.
And then you went into the house to visit Lotus, right?
Yes.
Now, Lotus didn't witness this, I assume?
No.
When you met in the neighbor's spot, did you show Miss Olson the damage?
I did. We didn't meet there. We met outside of her house as I was leaving Lotus's house and she was going in. I confronted her about it, and then...
Tell me what you said when you say you confronted her. Tell me what you said to her. That's the question.
I said, "Are you aware that you hit something earlier? That was my car. Do you want to go check it out?"
Is that the conversation that you had with her outside?
No, Your Honor.
Are you trying to tell me that it happened earlier in the year and your dogs just found the hole? They had never been out before? Is that what you're trying to tell me?
Yes, ma'am.
Oh, I don't believe that, sir.
"17-year-old Bella North and her mother, Angela North, claim business owner Heather Olson owes for car damage."
Okay, tell me what you said when you say you confronted her.
Heather knew that she...
Don't tell me what she knew. Tell
Okay.
me what you said to her. That's the question.
I said, "Are you aware that you hit something earlier? That was my car. Do you want to go check it out?"
And she said?
Yes, of course.
And?
And then she did. She said, "Okay, the damage will probably be at least $600. And then she told me to go to an auto body shop, which I did. And she told me to get an estimate, which I did. And that was that.
Okay. Is that the conversation that you had with her outside?
No, Your Honor.
Tell me your version of the conversation that you had with her. Will you acknowledge that you met her?
Yes, when Bella and I met outside, she came at me accusing me of hitting her vehicle. Sorry.
Tell me what she said to you and you said to her.
She did say that I hit her vehicle and asked me to look at her vehicle damage. Immediately, I agreed to go look at both vehicles. And we looked at both vehicles. We both took photos of both vehicles. There was minor damage all the way around her vehicle, and I could not see any damage on mine. And I could not understand.
Just a second.
Yes.
Did you look at her vehicle?
No.
At that time? Why not?
We never looked at her vehicle. We only looked at mine.
Well, she drove in her vehicle.
Yes.
Why wouldn't you look at her vehicle?
It was about my vehicle. We were concerned with my damage.
It was your damage, but you were contributorily negligent.
I understand that, yeah.
Well, you'd understand that, so you'd want to look at her vehicle, too. Did you ever have a conversation with her and say to her, take her to a body shop?
Yes, Your Honor, that is true.
Okay.
I said, go ahead and see if they can find any damage that could have been caused by an accident like that, because I didn't believe it, and I didn't remember ever hitting her, and I thought it would be more like $200. Bella did come back with an invoice for $600 or $700, and then that was shocking to me because I couldn't believe that there was any damage just from that. So it turned out that the body work she was going to have done was basically her entire bumper and both headlights, which is seems like a lot.
Which is not the damage that, even assuming arguendo that you caused, she only showed me a picture of one headlight. Can I see the estimate that you have?
Do you want all three or just the one that she...
What do you want to tell me, Lotus?
I was a witness to that conversation.
Oh, I'd like to hear it.
Yes.
Stand up, move over. Are you living at home?
No longer.
When did you move out?
I would say the second week of June.
Did you have a fight with your mother about this event?
No, I did not want to get involved.
Great. Okay, tell me exactly what you heard your mother say.
She said, "This is my auto parts place, and if you go there, I will pay for those damages."
Okay, do you remember that conversation?
Basically, that's correct, that I said, go to this bodywork person that I know, because I thought he'd see that's silly and turn her away.
But your daughter is making a statement. Is that the statement? Go to my body shop and I'll take care of it.
Yes.
Okay, fine. Can I see the receipt that makes it? Have a seat, please. This says customer pays $0, insurance pays $7.95. In my historical brain of information, an estimate from a body shop when they believe insurance is going to pay for it is always a little bit inflated. Did you have your car fixed?
Not yet.
Not yet. Okay. You agreed to pay for the damage. That's what you agreed to. I will tell you, if you had not agreed to pay for the damage, I would find the plaintiff 50% responsible for this accident. She was as negligent as you were in hitting her car, and I do believe that you hit her car. So absent an agreement by you to pay for the damage, I would actually split this between the two of you and find the plaintiff 50% contributorily negligent. But since you agreed to pay for the damage and you acknowledge you agreed to pay for the damage, I must rely on this bill, which is $795. Judgment for the plaintiff. Thank you.
Thank
Court
you.
is adjourned.
I don't think it caused too much friction as we were never that close.
Still in shock.
Obviously, I'm still close with her daughter, so it hasn't caused too much friction.
I agreed with your judgment to give the plaintiff a little bit of money, but I'm not so sure on the contributory negligence reasoning. I agree that parking behind someone's vehicle is never ideal, but if you're going to operate a motor vehicle, you have to check your surroundings. I think that people have to be more careful when they're
People have
driving.
to be vigilant, but you know, just because there's an accident doesn't mean it has to be always someone's fault.
Sure.
That's why they invented the doctrine of contributory negligence. I actually think it was just lazy of the plaintiff to park in a spot. She wasn't paying attention to her surroundings because she didn't see the defendant in her car. The defendant ran into her car, didn't see the little car behind. I believe that they were equally responsible. But for the agreement that the defendant made, I would not have awarded her the whole thing. I would have awarded her 50%.
Seemed like just a case of blind spots and bad timing.
Yeah, that's true.
Case 2078, Ali versus Miller. All parties, please step forward.
Syed Ali is suing dog owner Abra Miller for car damage from a dog attack.
Mr. Ali, you bought yourself a Tesla.
Yes, ma'am.
A new one?
Yes.
When did you buy it?
I bought it on 6th of June.
Of this year?
Yes.
How much did you pay for it, sir?
68.
And there was a loan on the car?
There's a loan on the car here.
So you have full insurance on the car?
Yes.
What's your deductible?
Deductible is $1,000.
$1,000.
Yes.
This is what your case is about. You were going to check on a child's house of yours.
Yes, ma'am. It's my son's house. I go there every day. We bought that house for on my son's and my name. It's for my...
Oh, so it's a house that's jointly owned by you and your son?
Yes, ma'am.
But you don't live there regularly?
I don't live there.
And where does Mr. Miller live?
He lives on a different street, but his backyard and my backyard, they meet each other in the back.
How long have you owned that house?
Since 2014.
Long time.
Long time.
Have you met Mr. Miller?
I met him a few times, yes.
Mr. Miller, you recall meeting Mr. Ali?
Yes, ma'am, once.
Okay, but you've met him?
Yes, ma'am.
Before June 6th?
Yes, ma'am.
And your son lives in the house. Anybody else live in the house? You live in the house. Is this a tenant in the house?
She's a tenant. Yes.
Does your son have dogs?
No.
And does the tenant have a dog?
She does.
What kind of dog?
A Yorkie.
You have a Yorkie?
Yes.
It's a small dog.
Yes.
Yes.
So you have one Yorkie in the house. And you have 2 dogs.
Yes, ma'am.
What kind?
A pit bull breed.
Pit bull?
Yes, ma'am.
And the other?
No, both are the same.
Both are the same.
One's actually the mom and the son.
And how old are they?
The mom's 10, the son's about 8.
And you've had them for years?
Since they were born.
So June 16th, you go to check on the house.
Yes.
Tell me what you saw when you pulled up to the house.
When I went there to the house to check my mail, I saw 2 dogs.
Where did you see the 2 dogs?
I saw them in the porch.
On your porch?
Yes.
Okay. Had you ever seen those dogs before?
No, I never saw them before.
Could you describe them for me?
They're a big size. They are black and white, and they're...
One was black and white or both black and white?
No, the one is black and white, and I have some pictures of them.
Oh, you took photos?
Yes, ma'am. Yes, Judge.
You took photos of them on the porch or initially when you saw them?
After I saw them, I was walking out, then I took the picture.
Okay, may I see the photograph? Take out the photographs of your dogs. Would you say, give me both photographs, please? I see. One is black.
One is white.
And one is fawn color and white. Are these pictures of your dogs?
Those are pictures of my dogs.
At his house?
Yes, ma'am.
Okay, so now your dogs are out. You're not at his house, just your dogs.
Just the dogs.
Okay, so now I got it. So you took pictures of the dogs the day of this incident at your house.
Yes.
And these are your dogs?
Yes, ma'am.
Okay, tell me what happened with your car. Most states now exclude certain dogs from their policy. One that's right on top of the list are pit bulls. You are aware of that.
Syed Ali claims dog owner Abra Miller owes for car damage after his dogs attacked Syed's Tesla.
Okay, tell me what happened with your car.
Then I realized that I think maybe I need to get away from them because they were very ferocious and growling. And I quietly walked away from them, go to my car, lock myself in, and I said, I need to get out. So I saw them, they were jumping all around my car and biting everything.
They were biting what?
Biting the right side of the tire, this side, and the rim and all that.
What your claim is that the dogs caused a substantial amount of damage to your car.
Right.
May I see the photographs of the damage?
Yes, ma'am.
So the car had scratches on it, I see. And what about the wheel rim? Is that, you're also showing me the scratches on the wheel rim?
Yes, they were biting all the rims and the tire, and they went into the front and bit on the bumper.
May I see that? Okay, have you seen the pictures?
Yes, ma'am.
He sent you pictures of damage.
He sent me some pictures, yes,
of the damage. Okay, so now, Mr. Miller, what Mr. Ali is saying is that your dogs, who he has pictures of, that you acknowledge are your dogs,
Yes, ma'am.
caused damage to his car that he had for a week, that he paid almost $70,000 for. The dogs were clearly outside of your control. They were out of your control because you acknowledge that the photographs of them are without collars, without leashes, nobody around them, and the photographs are taken at his house. I'd like to hear a defense.
Your Honor, there was no way for my dogs to have done the damage. My dogs are older. One of them has no teeth. We have to put water and stuff on her food just so she can eat. The other dog's teeth are filed down. Both of them are up in age. My dogs have never harmed anyone. I have 10 cars of my own in my yard, and I've never had my dogs biting any tires, any damage.
Mr. Miller.
Yes, ma'am.
That's why they call dogs dogs. They're animals.
Yes, ma'am.
Because on one dog, it looks as if the incisors are filed down a little bit. Still has teeth, but the incisors are filed down. Is what you're telling me that that was a natural process, or you had them filed down?
No, ma'am. Absolutely natural.
Absolutely not what?
Absolutely natural.
Absolutely natural. Okay, so the dogs still have teeth. They are smoother rather than sharp, but they still have teeth. Okay, but that's why they're dogs. You weren't there to witness this, so I have to assume that what the plaintiff tells me is true because his evidence is consistent with that. He has photographs of your dogs outside of your control, no collar, no leash, at his house. And he said that he took those pictures on the date of the incident, and he has damage to his car. Now, if somebody has that problem, they don't want to blame the wrong person. And the dogs he's identified as causing the damage are your dogs. I'm still waiting for a defense. You mean the fact that they've never done it before you think is a defense?
No, ma'am, not.
What were they doing outside of your control?
They actually got out of my yard from a previous tenant of his dogs that dug a hole up under my gate.
Just a second. So a previous tenant of his had a dog.
I had several dogs.
Several dogs.
Yes, ma'am.
Doesn't live there anymore, dug a hole under the fence. When did that happen?
That was earlier that year.
Okay, and when did you first discover it?
I didn't realize it until after this incident.
Are you trying to tell me that it happened earlier in the year and your dogs just found the hole? They had never been out before? Is that what you're trying to tell me?
Yes, ma'am.
Oh, I don't believe that, sir. You're responsible for his deductible. Did you have the car fixed?
No, not yet, ma'am.
Why not?
I have an estimate, and I approached him of that, and I said, let's see if we can do something about this.
Mr. Ali.
Yes, sir.
You
Yes,
have insurance.
Yes.
And you have insurance for this type of problem.
Yes, Judge.
And you have a $1,000 deductible.
Yes, Judge.
Did you advise your insurance company?
I wasn't, because I was trying to see what my good friend neighbor wants to do.
Do you own your home?
Yes, ma'am.
Do you have homeowners insurance?
Yes, ma'am.
Does the homeowners insurance exclude your pit bulls?
Do they exclude them? I'm not sure.
Well, in what state do you live?
Florida.
In Florida. Would you look up and see what's the name of your insurance carrier?
I'm not sure, Your Honor. I just switched insurance companies.
Did you have insurance, homeowners insurance, in June?
Yes, ma'am.
You did?
Absolutely.
Well, did you inform your insurance company that there was a problem?
No, ma'am.
Why not?
Because I was trying to get an understanding of what was going on.
I'm just telling you what's going on. So now you know what's going on. Your dogs caused damage to his car. Most states now exclude certain dogs from their policy. One that's right on top of the list are pit bulls. You are aware of that.
Yes, ma'am.
And either you pay a higher premium or the insurance company says we're not insuring them. You do understand that?
Yes, ma'am.
Okay, so now you understand. Does your policy exclude your pit bulls?
I don't think so. No, ma'am.
Well, I don't know, and I don't know how to find that out unless you can give me a definitive answer, Sarah. It depends upon the insurance company.
It does.
Yeah, and you don't remember your insurance company. So Mr. Ali, he's not paying the $8,000 that it's going to take to fix your car. That's what you have insurance for. Okay? But he's going to pay the deductible. You have insurance. It's a brand new car because you have a loan. So you must have insurance, which I'm sure you do.
Yes, I do.
Then if you were having a difficult time with Mr. Miller and his insurance, which I could probably understand because it may exclude his dogs from the policy, you have to advise your insurance company. And I don't understand why you didn't do that.
But I was going to see if he wants to go ahead and fix it.
Well, he's not paying $8,000 to fix it. He's going to pay the $1,000 deductible on your policy.
He was suggesting me that he could just go and get a spray paint and paint that little thing. And I didn't like that idea. And I said, let's go to Tesla and have it done by the properly from...
Absolutely. I agree with you. It's a brand new car. You should have it done by Tesla through your insurance.
That's true. Yes.
Good. Judgment for the plaintiff in the amount of $1,000, which covers your deductible. We're finished.
This court is adjourned.
Animal control said my dogs were so loving and peaceful. They showed no aggression to them.
I mean, I like to have people as good neighbors.
Even after they put the pole and the hoop around their necks, my dogs were wagging their tails.
The neighbor's dog has some damage to my car, and I want the neighbor to be up to that responsibility.
The plaintiff bought a new Tesla and has a loan on the Tesla. When you have a loan on a car, you're required by the lender to maintain insurance, both collision and liability. This is not a malicious act. It was a careless act. And I think he should use his insurance to pay for it. I think it was fair. I don't think that there was an issue of fact. Did you?
No, I didn't. I think that that was fair because you have insurance for that purpose so that you don't have to pay $8,000 out of pocket to fix damage from an accident. So he should have used it.
And Tina Smoody are suing their former son-in-law, Dalton McDonald, for unpaid loans.
Court come to order. All rise.
Have a seat, please.
Hello, Judge. Case 2082, Smoody versus McDonald.
Thank you.
You're welcome.
Mr. and Mrs. Smoody, the defendant used to be married to your daughter.
Yes, Your Honor.
And according to what I've read, they were married for about 5 years?
Yes.
The thrust of your claim is that he owes for a couple of things, for rent and the balance of a truck. That's your lawsuit against him. I'd like to know, do you know the date of their marriage?
3/16/2011.
And your ex-wife's first name?
Jacqueline.
And when did you and your former wife separate?
In 2020.
And you had 2 children. How old are they now?
They are 5 and 8.
And who has custody of the children?
Dalton has physical, and they have joint custody.
Just a second. So he has custody of the 2 younger children?
Yes.
That's a yes. How long have you had custody of the 2 children?
Since July of last year.
At some point during the marriage, there was a truck purchased.
Yes.
Who purchased the truck?
Dalton purchased the truck. I co-signed for it.
And when was it purchased? Month and year?
June of 2017.
Was that the only car that they had?
Yes.
So that was a family car?
Yes.
And in 2017, was your daughter working?
Yes.
So both parents worked. And both parents, I assume, pooled their money and I assume made car payments.
Yes, Your Honor.
Yes.
Is that correct? Both. And then they separated in 2020, and at that time, the children came to live with you.
Correct.
And you took the truck.
Yes.
By agreement with your now ex-wife.
Yes.
In 2020, who made the car payments?
My husband did.
Is that correct?
Yes. I made all of the car payments on that vehicle. All of them, from the time it was purchased until we paid it off.
Okay, so what you're telling me is from 2017, you made all the car payments.
That's correct.
Did your daughter and son-in-law make any of those payments?
Not directly, but they paid toward the balance of the money that they were.
You paid for the truck.
That's correct.
Since 2017, since they
correct.
were married.
Yes.
With no reimbursement.
I took payments out of my daughter's check.
Just be very, very careful with me, sir. I want you to be very careful with me. I read that, what we call in Yiddish, babamaisis in here, that you took money out of your daughter's check. Babamaisis, it means grandma's tale. It means it's not true. It means it doesn't sound right to me. I read it in here. Don't try to repeat it here because that won't be good for you. Okay, I'm going to believe you if you show me copies of her checks that you made to her with withdrawals from money she owed you. That's all I want to see. Do you have that?
I do not.
Not, of course not. Now, he has the truck, and this was clearly either a gift or a marital debt. Either one of those two things. It's either a gift or a marital debt. It was a family car that was used by your daughter, her husband, the grandchildren, with, according to you, no reimbursement, according to you, except this ridiculous reimbursement from your daughter's check, which I don't believe, so I'm not even going into it, with no reimbursement 2017, 2018, 2019, 2020. And when your daughter and the defendant separated in 2020, according to him and according to you, he took the truck and the children. And that was with her consent or not?
Yes, it was.
With her consent. Is that so far right? That's what you're telling me.
It's accurate.
Right. Did you intervene in the divorce proceeding and say that there is money owed, marital debt owed, and part of the marital debt is this loan on the truck?
No.
No. The answer is no, you did not. It would also be fair to say that you don't know how much, according to you, she paid for the truck.
I do, Your Honor. I have that ledger that I have. I would go to her each week and say, Jacqueline, how much can I take toward the loan? And that's how much I would take off each week.
All you have to do, sir, is show me. Otherwise, this is a whole bunch of nonsense.
Yeah.
It's a marital debt. You did not intervene in the divorce proceedings and say, listen, this is a debt that's still outstanding, whatever it is, $2,000, $3,000, $4,000. You didn't do that. Now, the only thing that you can say to me with regard to this truck business is if you had, had an agreement with the defendant in 2017 to pay the truck. And be very careful, because what you've told me is he didn't make any payments to you from 2017 ever.
He made some payments.
Just a second. Interesting. Show me where he made payments. Did you give him a receipt for payments?
No, this is a small town, and
It's not a small town, it's a family, sir. It's not a small...
I do have the ledger.
I'm not interested in a ledger you created. It's self-serving and therefore inadmissible and created for the purpose solely of this litigation and not created at the same time that the event took place. I might even cut you a little slack if you had a ledger, a book with entries in it at different times from 2017 in different ink, with a day, how much was paid back on the loan. I guarantee you do not have that. You have a very nice piece of white paper that you created for me. Is that correct? That is correct.
That is accurate.
Okay, so I'm not interested in your ledger. That's not a ledger. That's a document prepared for the purposes of litigation. So I want you to tell me what conversation you had and when with Mr. McDonald about paying for the truck. They bought this boat from you.
Accurate.
And how much did you sell it to them for?
$2,500.
Did they pay you for it?
No, part of that was put on the ledger, and part of it was cash.
You know I'm not buying your whole story.
Herman and Tina Smoody claim their former son-in-law, Dalton McDonald, owes for unpaid loans.
Now, I want you to tell me what conversation you had and when with Mr. McDonald about paying for the truck.
That was from the very beginning, because I was paying all their bills.
Just a second. I don't care whether you were paying their bills. I understand you were paying all their bills because they came to live with you for a brief period of time because they were evicted for whatever reason, and that was sometime in 2016. Okay. So I understand that you were paying their bills. Sometimes that's what parents do. They pay their bills.
We were paying their bills because they had no checking account.
That doesn't matter to me. I want to know your conversations with, where did it take place? Because you're not suing your daughter, you're suing him.
The conversation was when we rented the farm for them, which I know is not with the truck, but the landlord would not let them rent from them because they had terrible credit.
We'll get to the rent later. Stick with the truck. Don't talk to him when I'm asking him questions.
Well, the truck was the same thing. We put that on the ledger then, or on the running total, and they agreed. They both agreed that they were going to pay us off.
Okay.
He came over on Labor Day weekend, and I showed him the ledger, which he saw all the time.
No. Don't tell me what he saw. Don't tell me what he saw. If what you're saying is you showed him the ledger when he came over with the boys,
yes,
and he was going back to Minnesota,
right,
and he brought the boys to see you to say goodbye?
Correct.
Okay, so far, it's very nice. You have a reasonable relationship with him, and certainly your daughter was clearly overwhelmed because courts do not usually split up children, so they must have felt that the children's best interests would be served if they remained with their father. Clearly what happened, the father came over to you to let you say goodbye to the children, and when he came over to let you say goodbye to the children, let me understand what you're saying to me. What you said to him was, not thank you for taking over this responsibility. Your daughter had more children than she could take care of, physically or financially, right? Clearly.
Yes.
Clearly. So what you want me to believe that two nice people who took in their daughter with her two kids and a husband and bought a truck and made arrangements for them to have someplace to live, that these two nice people, when he came over, because your daughter couldn't take care of her children, and he brought them to say goodbye, you said, it's very nice. I want you to take a look at this ledger and see how much money you owe me. That's what you're asking me to believe, right? I'm going to let you live with that fantasy that I believe that.
And so I did give him the balance of what he owed me on the rent.
No.
And on the truck.
Nice.
And
he
he looked me in the eye, he shook my hand and said, Jerry, I promise I'm not going to screw you on this. I'm going to make those payments.
Make payments for what?
On the rent and on the truck.
Okay. Did you have that conversation with him?
No, I did not, Your Honor. The conversation was when I came up there the last time, Jerry was trying to sell his fishing boat, so I posted it on Facebook, and I sold it for him.
In what month and year?
That would have been September of 2020. After selling the boat, he gave me $1,200 for helping him.
How much did he sell the boat for?
It was $4,700.
So that was after you'd already moved?
Correct.
With the children?
Yep.
Okay. He helped you sell the boat for $4,700? Just answer my question.
No.
Did you give him $1,200?
No. He bought that boat from me a year prior to that. He had it.
So they bought this boat from you?
Accurate.
When?
That would have been in the spring of 2019.
And how much did you sell it to them for?
$2,500.
Did they pay you for it?
No, part of that was put on the ledger, and part of it was cash.
You know, I'm not buying your whole story. I'm not buying your whole story because what
Your
if...
Honor, I'm telling you the honest to God truth.
No, I don't think so. I don't think that I would have sold people who had no credit, who couldn't buy themselves a truck, so you had to co-sign for the only means of transportation that they had, who couldn't pay for their rent, who couldn't pay their bills because of their bad credit. I don't believe this whole scenario about selling them a leisure boat for $2,500. It's mind-boggling that you would think that an intelligent person like me would accept that. Okay, forget the truck. You have the truck now.
Yes.
Okay. You haven't finished your story with me, so sold the boat, and he gave you $1,200.
Correct. I gave him the $1,200 back, which made us even on the truck payment, and he gave me the title. Tina signed it, and then I brought it back to Minnesota and put it in my name.
Okay. Who signed it?
Tina signed it.
My name was on it as well.
Your name?
Yes.
As joint owners with him?
Yep.
Co-sign it.
Oh, interesting. In what month did Mrs. Smoody?
Yes.
Sign over the car to you?
The same day that I gave Jerry the $1,200, that would have been in September.
Now, do you remember the $1,200?
No, it was $1,000 that he paid toward the loan when I sold the boat for him.
Okay.
And it was his boat that I sold for him.
Okay. You did not create this as a marital debt. It absolutely was a marital debt. So I'm dismissing that portion of your claim that deals with the truck. Now, let's deal with the rent. The rent that you're talking about was rent in what property?
The farmhouse that they rented.
From when to when?
2016, November 2020.
And over the years that they lived there as a couple.
Yes.
The rent was paid to a landlord.
Correct.
by you.
Yes.
Is that right?
Correct.
And they, your daughter and her husband, would give you cash, checks, or whatever to cover the rent.
Yep.
Yes.
And how much did they give you to cover the rent?
When we started out, rent was $800, and later on he raised it to $900. We never made it a set amount each week. They gave us what they could. And we've done this before in the past, and they've always paid us back.
Well, then you should have sued them and listed all of this as a marital debt in the process of their divorce. So it could all have been...
We're handling Jacqueline in another way.
You what?
We're handling Jacqueline alone.
I don't understand what that means.
Well, you're saying it was marital.
Just a second. Does that mean that you've already served your daughter with a summons?
Not yet, no.
Of course not. Of course not. And you did know when they were divorcing. Yeah. You did know when they were divorcing. I'm not buying anything of this lawsuit, most of which, at least the rent part, is totally stale. I'm just curious, Mr. and Mrs. Smoody, somebody wants to answer this question for me. Mr. McDonald has custody of your two young grandsons, who I assume that you were close to because they lived with you in your house. And you seem like
live with us. The two boys came back to live with us.
From when to when?
December of 2021 until July of 2022. 6 months we had them.
Just a second, 2022. Was there a court proceeding?
No.
But then in July, they went back with their father.
That's accurate.
And they've been with their father since?
Yes.
Okay, so the boys lived with you for 6, 7 months.
Right.
Was that an acrimonious transfer? That's what you meant when you said any employer that has gone through all that paperwork and red tape, as I have, will do anything to avoid it. The anything is firing the employee.
Herman and Tina Smoody are accusing their former son-in-law, Dalton McDonald, of refusing to pay back loans.
Was that an acrimonious transfer, or was it something that you both...
What happened there was he called my husband to see if
No, don't tell me what he said to your husband.
Okay,
I will tell you then. He called me in December and asked me if I would please take the two boys. I told him, I will take them, Dalton, if you start making regular payments.
Oh, well, we're out of the money business now, sir. What you're saying is from 2017, when the children were in his custody, your daughter may have been there, but they were in joint custody, and then he maintained custody of the children, and during the time he maintained custody of the children, there was no question whatsoever that he was not paying you back money. He did not make any payments to you. Occasional here and there, we don't keep records. All of a sudden, now you have the boys with you. And then in July, he comes back and he takes the boys back. All I asked you was whether that was an acrimonious, which is an unpleasant, or a harmonious transfer of the children. Mr. Smoody was in July.
In July, it was acrimonious because at that point, he'd gotten a restraining order against me.
Against you?
Against me while we had the children. Because I sent him a letter saying that I wanted payment, and he went and got a restraining order against me because they took that as a threat.
I'd like to see the letter, please, Kevin. And this is what needs to happen moving forward.
That's correct.
You need to mail me $200 on the 1st of every month and $200 on the 15th, starting March 1st, 2022. If I do not get these payments on time, the following will happen, which is, you could say, I'm going to sue you, right? I'm going to sue you, but that's not what you say. You say, I will go to your boss and talk to them about garnishing your wages. Any employer that has gone through all the paperwork and red tape, as I have, will do anything to avoid it. So that's a threat. What you're saying is, I'm going to call your boss and tell him that I'm going to sue you, and then your boss is going to have to go through all the red tape of what it means to have a garnish on your salary. You have to go through accounting, and they have to deduct it. And no boss wants to do that, which is in effect say, so either you pay me or your boss is going to fire you. That's what you meant when you said Any employer that has gone through all that paperwork and red tape, as I have, will do anything to avoid it. The anything is firing the employee. The only thing that
you can legally fire somebody.
Just a
for
second.
that.
Whether you can legally fire them or not, that's what you were threatening. That's what that said. So we got an order of protection against you.
Correct.
And?
Then I didn't fight it because I didn't anticipate having any conversations or contact with him.
When you wrote this letter,
Yes.
you had the boys.
Yes.
Right. Not before.
No.
Not before. And he had had the boys for some time alone.
3 months.
He had had the boys for some time alone. Okay. Let's go back to my original question, which was, when the boys went back to their father, was it acrimonious or harmonious?
It was not good.
Well, so tell me your version of what happened.
The reason it was acrimonious is because he knew very well that once we got him, we put him on a strict schedule. 8 o'clock, brush your teeth, 8:15, pajamas, 8:30, bed.
Where was your daughter living at this time?
With us.
Yeah, just to say, if you're going to interrupt him because you want to get it out,
I'm sorry.
That's not going to be good for you.
She had a room at our house.
Just a second. So your daughter was living with you. So what you're telling me was your daughter was in the wind someplace.
Accurate.
Okay. You know, you had her for a long time. He only had her for 5 years. And I can understand the sadness if your daughter is in the wind and not being responsible, sir. But that doesn't mean he has to shoulder all the burden. Right now, he's shouldering all the burden of supporting the 2 children, which I assume you're doing. They're living with you. And so are you working?
Yes, I am.
And he's working. Your daughter is not.
She's working 2 jobs.
She always has.
If she's working 2 jobs, why was she in a room?
She wasn't renting. She was living there free.
Okay. So now let's get back to this acrimonious transfer by the children back in July.
Dalton called me, or called the kids.
Okay, so he called the
after
children.
bedtime.
Okay.
Called
And
my wife's phone 4 times. Ring, 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 ring. And she wouldn't answer because kids were in bed. And then he called my phone twice. The second time, I have an old flip phone. I flipped it, walked in, because now I hear the boys are awake. I let them talk to the boys. And then I took the phone back and I said some naughty things to him and hung it up.
What did you say naughty things to him for?
Because I was very angry at him. Can I use some swear words that I used when I told him?
No, I assume you used some terrible words.
Yeah,
but
I just told him, don't call me anymore.
Is there any reason that you discussed with your wife why she didn't answer the phone?
Because the boys were already in bed. He had done that before.
You already told me that you heard the boys, so you took the phone into his room.
After the phone calls, they woke up.
Is what you're telling me that the first time that he tried to talk to the boys, that you or your wife didn't answer the phone?
I think it probably happened once or twice prior, and then we told him, don't do it anymore.
Okay, fine.
And this time we were fed up.
Fine. So that's when he said, I'm coming to take the boys.
No.
Well, when did he say he was coming to take the boys?
Not until July. Jacqueline told us that Dalton was going to be taking the kids once they got out of school.
Okay, I'm going to take the pain out of this case, and I'm going to do it relatively quickly. I think, Mr. and Mrs. Smoody, that this lawsuit was very ill-advised. The defendant doesn't owe you any money. He doesn't owe you any money because if there was money owed, it was a marital debt, and it should have been taken up at the time of the divorce, listed as a marital debt, and then it could have been fixed by the judge who approved the divorce how much and by whom is owed money. You chose not to do that. It was only after a very acrimonious set of circumstances, roughly 5.5 years later, after this truck was purchased, that you chose to exercise any prerogatives with regard to a debt, except this letter, which threatens to go to his boss to get him fired if you don't stop making payments, and that was only after the 2 children came to live with you and were sort of overwhelmed. You have to understand, Mr. McDonald, who I think probably is trying, he's got the 2 boys. It got very complicated, but it's not a lawsuit, and I would make nice with him. He's got 2 children that you probably want to have some connection with, and this lawsuit certainly doesn't help that. Well, anyway, for all the reasons that I've stated, your lawsuit's dismissed. We're finished. Thank you.
This
court is adjourned.
He owes us that money. He admitted he owed us the money.
I think the judge was absolutely correct.
He promised he was going to pay us the money back.
I don't owe Jerry any money.
Kids are irresponsible, have no sense of honor, duty, respect, responsibility, nothing.
Really should be a family thing, and maybe one day it can go back to it.
This was a great case that explains why a lot of cases in civil court have a statute of limitations before you can bring a certain kind of case, because here it was hard for us to understand why they would not have requested that money back earlier. So when you ask for it now, years down the line where so much has happened, court's not so likely to feed into that because you don't know what the real motivation is behind it.
I agree. I think it's really foolish of them, especially since their ex-son-in-law has total custody of these two little boys, for them not to maintain reasonable relationship with him.
It was a good showing, though, that if you do give money to your daughter, son, and their significant other, and they do get divorced, you should follow that divorce proceeding. So if you do have a claim,
legitimate debt.
Dean Miller is suing vehicle owner Robert Pena for damage after his 17-year-old son hit Dean's car.
Court come to order. All rise.
Have a seat, please.
Hello, Judge. Case 2076, Miller versus Pena.
Thank you.
You're welcome.
Mr. Pena, is that your son?
Yes, it is.
The one who was driving the car?
Yes.
Okay, good. You stand up next to your father. Mr. Miller, is your claim that the defendant's son hit your car that was parked in a parking lot?
Yes, Your Honor.
And it was parked in the parking lot of a high school?
Yes, Your Honor.
Do you work in that high school?
Yes.
As what?
I'm a teacher.
What do you teach?
I teach what's called on-site continuation. It's a continuation classroom for 10th through 12th grade students.
Do you go to that school?
Yes, Your Honor.
Okay. On what date did you park your car when you allege it was hit?
I was on March 8th, Your Honor.
You were in school that day.
Yes, Your Honor.
Now, you should know that in reviewing this case, Mr. Miller, because he was not there when his car was hit.
Correct.
Correct? And so he alleges that it was you who hit his car and then left the scene. Your father said it was not you who hit his car, and there's no proof that it was you who hit his car. That's what your father said. Before you answer my questions, I'm going to tell you that Mr. Miller has a video that he says was taken by school cameras that were zoned onto the parking lot that demonstrates that you actually did hit his car and leave. Do you understand?
Yes, Your Honor.
So now we're going to go back to March 8th, and you're going to tell me what happened with Mr. Miller's car.
So I drive myself to school every day, or at the time I was driving myself to school because that was my only way of getting to school.
Did you have a driver's license?
At the time, no, I did not have a driver's
So you were driving a car without a driver's license.
Yes, Your Honor.
And what kind of a car were you driving?
It was a 1991 Camaro.
Where did you get the car from?
Me and my dad had gone off the street. It was a project car.
How old are you?
17.
Did you try to take a driving test?
Yes.
When?
Back when I had turned 17, actually, in February of last year.
And you didn't pass it?
No.
Did you take the written test?
No.
What did you take in February?
The practical test.
Just the practical test, the driving test.
Yes.
And you failed that.
Yes.
So despite the fact that you failed that, you drove the car, and your father knew that you were driving the car without a license. That's a yes or a no?
Yes.
Was there insurance on this car, Mr. Pena?
No, there wasn't.
So no insurance, no license. So far, not good parenting. You understand that, Mr. Pena?
Yes.
Great. Okay, so you drove yourself to school and?
There's a parking lot that all the students, teachers, anyone who goes to school, really, they can park
Yes,
at.
nobody suggests you were trespassing in a place you weren't supposed to be.
Yeah, so every morning I would park in...
Not everyone, look at me. That day, Mr. Miller's car.
Yes, Your Honor. That day, March 8th, I came to school as usual and I parked in my area, and then one of the on-school deputies that the school has, he pulled up right behind me as I parked, and he asked me for my information, he asked me for my name, my school ID.
I want to know what happened with Mr. Miller's car.
Oh, nothing happened with Mr. Miller's car.
So what you're telling me is that you did not hit Mr. Miller's car. Is that what you're telling me?
Yes, Your Honor.
What car were you driving that day?
1991 Camaro.
What color is it?
Red.
How long have you been going to that school?
It's my 4th year going.
How many other people drive a 1991 Camaro? Red. Nobody.
Nobody.
And so I'm going to watch this video. Sarah, do we have the video?
I have it. So, wait, you'll see it.
Okay. You had a truck.
Yes, ma'am.
Okay. Okay, so there's no question you hit the truck. Do you want me to show you the video?
No, Your Honor.
Well, if you don't want to see the video, that's because you told me a lie.
Oh, yes, I'd like to see the video.
Absolutely. Going to watch very carefully. You pulling into a spot, and the truck moved as you were pulling in. Have they shown you the video, Mr. Pena?
They show me a different version of that video.
Well, I've just seen the version that I saw. Got it?
Yes, Your Honor.
Saw the truck move, did you?
Yes, it did.
When you were pulling in next to it?
Yes, I was.
When you were pulling in next to it? So that didn't happen because there was an earthquake. That happened because you hit the truck.
Yes, Your Honor.
Fine. Now we understand each other, Mr. Pena?
Yes.
Great. That's a yes. Okay. Can I see pictures of your truck, please, and the estimate to repair it?
Yes, Your Honor.
Have you seen the photographs?
Yes, Your Honor.
Okay. Totally consistent, right? Okay. Mr. Miller, you're from California?
Yes, Your Honor.
Do you regularly teach today?
Yes.
So you had to take a day off.
Yes, I have a substitute today, yes.
How many days off are you allowed?
10 per year. I've accumulated quite a few because I don't take many days off.
You get paid for those days?
I get compensated because I have sick days or personal necessity days.
The reason I'm asking you these questions, Mr. Miller, because it's no question that you are entitled to have your car fixed. But that's, to me, even though that's all you're requesting, I think the fact that Mr. Pena allowed his son to drive a car without insurance and without a license, not only without a license, but knowing that his son took a driving test the month before and failed it, which means that he was not a good driver. Not a good enough driver to get a driver's license. And I have a lot of people in my family that don't drive well, that I don't like to be in the car with. But they all have driver's licenses because they managed to pass a driving test. So I know that you are only requesting the $1,524, but I'm actually awarding you $2,500.
Thank you, Your Honor.
And that's for the aggravation of, instead of Mr. Pena saying to you, I'm sorry, my son hit your car, because either his son lied to him.
Your Honor, can I say something?
Either his son lied to him, or his son told him the truth, but he lied to me. And he's the grown-up. He set an example for his son that said it's okay to break the law. Not only for you, because you take the car to school. Take the car to school, even though you failed. Take the car to school. It has no insurance. If you hit somebody in that car and you seriously injure them, that car has no insurance. Car has no insurance. He has nothing to lose. Car has no insurance, but the person who he hit, person whose property he may have destroyed, they have no recourse. You understand, sir? That's a bad parental example. You want to say something to me or not?
Yes, I do.
I don't care that you didn't like it. That's not, as a parent, the lesson you should be teaching. And whether or not you like the way the sheriff spoke to him, that is totally irrelevant to me.
Later.
I paid as much as I could supporting him. I wasn't getting paid rent for his room.
What happened is you both sort of took advantage of this rent moratorium.
Not true.
Dean Miller claims vehicle owner Robert Pena owes for damage after his 17-year-old son hit Dean's car.
Go ahead.
My thing I didn't like was how he got approached.
I don't care whether you like it or not.
That's what I didn't.
I don't care whether you like it or not. Did your son come home from school that day and say, I hit somebody's car?
No, he didn't.
No, he didn't.
Nowhere.
And just a second. And when you asked him whether he hit somebody's car, what did he tell you? Just be careful.
He said, I think. He felt intimidated
just a second.
by
I think.
the sheriff and him.
I don't care that you didn't like it. That's not, as a parent, that's not, as a parent, the lesson you should be teaching. First of all, you allowed your son to violate the law. You allowed it. And then, I mean, I would certainly know whether I caused that much damage. He knew that that car moved. So either he lied to you or you lied to me. And whether or not you liked the way the school official spoke to him or the sheriff spoke to him, that is totally irrelevant to me. That shouldn't be the takeaway from this. The takeaway from this is you're supposed to follow the rules. The rules are meant for everybody, and that includes you and your kid. Judgment for the plaintiff in the amount of $2,500. We're finished here.
This court is adjourned.
Police officer came behind me when I parked and accusing me that I'd hit someone.
The school deputy saw the video, knew the car, so he approached the student.
The person who I'd supposedly hit came out with a megaphone yelling at me.
There is no megaphone, so I don't know where that came from.
Telling me that I'd hit him. So I was kind of like freaking out. I didn't really know what to think.
If it happened to me, he could hit someone else. And
I didn't know I hit your car. Like, did I hit your car? Like, I didn't even know what to think. I could have sworn I did not.
This was fortunate that it was just a parked car in a parking lot.
It is time to get his license, yes, that's correct.
It's time to get the car fixed and just get some closure on this.
In our family, we would call that contact a love tap. And as someone who has had a few run-ins potentially with stationary objects, I will tell you...
Not potentially.
I will tell you, you know when you hit a stationary object, even if it's just a light little love tap. So I just thought it was outrageous that the defendants, father and son, they knew that there was a video and still took the position of, nope.
Well, his father's position was, I didn't like the way they spoke to my son, and therefore, I'm not responsible. They shouldn't have spoken to him. I mean, he's 17 years old, but he looks like a man. He's taller than his father, you know.
You have to take responsibility.
But you have to take responsibility and not drive a car, especially. You failed a driving test. The most basic thing. I mean, you know, we have
I will
people...
say, I did pass on the first try, so...
Yes, but we have people in our family who actually did not.
Okay, yes.
And they
will
didn't
not be
drive...
named.
And they didn't drive a car.
Yeah.
Until they could pass a driving test.
And their parents were the first ones to say, no shot until you pass that test.
Absolutely.
So parents need to be responsible as well.
Right.
Case 2104, Birkeland versus Lefkowitz. All parties, please step forward.
Shannon Birkeland is suing her former roommate, Ian Lefkowitz, for unpaid rent and eviction costs.
Ms. Birkeland, how long had you lived in your residence?
Prior to the defendant moving in?
Yes.
2 years.
And how long did you live there with the defendant?
A total of 5 years.
You
With
lived
the
in
defendant, I'm sorry, 3 years.
3 years.
This month would have been.
And for most of that 3-year period, what kind of work do you know that the defendant did?
Computer work and music producing.
How do you support yourself, sir?
I produce music. I don't do computer work.
Produce music for whom?
Various artists and brands and whatever.
How long have you been doing that?
Since I was 13 years old.
How old are you now?
32.
You have a corporation or an LLC?
Not currently standing, but I do have one that is out of commission right now that needs to be reestablished.
When was the last time you filed tax returns?
Last
April.
Last April, yeah.
And on your tax returns that you filed, how much did you indicate that you earned?
I receive royalties from a company called, and they take my taxes out automatically, so I'm not sure how much.
I'm asking you how much you reported your gross income was when you filed your tax returns in April.
They come automatically, is what I'm saying. I didn't file them. They're paid for and filed automatically by the company that distributes my royalties.
So is what you're saying you didn't file tax returns in April?
I assume that they're filed automatically through this company that pays me.
Mr. Lefkowitz, when was the last time you put a stamp on tax returns that you sent to the government?
I do not know.
Ever? You have to think.
No,
ever?
Like I said, where I make most of my money, if not all my money, comes through a company called, which they take out the taxes automatically before paying me. So I've never filed through that. I just assumed that it was already taken care of in that way.
You assumed wrong.
Okay.
Okay. There came a time, Mr. Lefkowitz, you lived there for 3 years, but there came a time when you stopped paying rent.
Correct.
And what was your rent when you moved in with the plaintiff?
$1,200 a month.
You had your own room?
Yes.
Bathroom?
Yes.
You moved in what month and year?
2019 in October.
And as you said, most of your money comes from royalties, and I assume that's royalties on past work.
Yes.
And you've been existing on that for how long?
8 years or so.
So how much do you make from these royalties? You pay $1,200 a month rent, you have a car. It's not an answer.
Yes.
You have a
how
car.
much do I make?
So you have a car, you have insurance.
Yes.
What kind of car do you have?
I have a Honda Clarity.
What year?
It's a lease. It's a 2021.
And how much do you pay a month for the lease?
$395.
Does that include insurance or does it not include
It
insurance?
does not include insurance.
So you pay an additional how much for insurance?
About $350.
So you spend $700 a month for your car.
Correct.
And let's get back to, you moved in October of 2019, your rent was $1,200 a month. And you lived there until when?
Until about 2 months ago. So September 4th or 3rd is when I moved all my stuff out.
And when was the last month you paid rent?
That would have been in December of 2021.
So you lived there January, February, March, April, May, June, July, August, and part of September. So at least 8 months that you lived there and didn't pay rent.
Well, I wasn't there for August, pretty much the
Your
entire.
things were there.
Sure.
If your things are there, you're there.
Okay.
Because that's part of what she's suing for. Rent that you didn't pay. Are you still living there?
No.
Why not?
I was evicted.
When?
The exact date is August 2nd. I do have my paperwork for notice to vacate and all that.
Just a second.
Sure.
On August 2nd of 20...
I'm sorry, that was the court date, and that's when the judgment was made, was August 2nd.
And when did you move out?
2 weeks later.
That's not true.
And you were evicted for non-payment of rent?
Yes, for 2 months. Yes.
Just a second. You were evicted for non-payment of rent?
Yes, for 2 months.
Well, show me that it was for 2 months. I just want to see that it was for 2 months and what 2 months those were.
That page right there.
No, you didn't leave until, let's say, September 1st.
That sounds more like it.
You didn't leave until September 1st.
I'm sorry, Your Honor. I did mistakenly speak. I do remember that the judge...
Don't tell me what the judge said. I'm asking you when you left.
Gave me 6 weeks from that date of August 8th.
What
so I left September 8th.
And you left at about the same time.
I left prior, but I called my neighbor at...
Just a second.
Yeah.
You left at about the same time.
A few days before.
Fine, that's at about the same time.
She actually left after that. I talked to a neighbor that said around the 14th that she was still there.
You can't tell me what the neighbor said. So that's why I stopped you before.
Well, I know there's a moratorium for COVID, and the government shut my business down.
That's what he
so
says.
I knew that I had protection.
He's saying the exact same thing you are in his answer. You two are soulmates.
Hey, no, Your Honor, I'm sorry.
Shannon Berkland claims her former roommate, Ian Lefkowitz, is responsible for unpaid rent.
Okay, this eviction notice is dated May 26, and it says that you didn't pay April or May.
Correct.
But both of you lived there in June. Did you pay June?
Yes.
Show me proof. Show me proof that you paid June and July. Show me proof you didn't pay April and May. Show me proof that you paid.
My proof?
Your proof.
Is in the fact that I don't owe any rent except for when the moratorium lapsed and I...
No.
I don't have a receipt. I don't have a receipt for payment.
Then just say I didn't pay rent for June and July.
I did not pay rent for June and
Well,
July.
just answer that question. So you didn't pay rent for June and July.
Yeah.
Here we go. And you didn't pay for April, May, June, and July. I know you didn't pay for August. There's no question you didn't pay for August, and you were actually there in August, so you didn't pay for 5 months.
I guess, yes.
Okay, yes. And the reason that you didn't pay rent for those 5 months was what?
I had spent all my savings on paying rent, and I had none left. I paid as much as I could, supporting him.
Just a second.
The best I could, and I...
What happened is you both sort of took advantage of this rent moratorium.
Not true.
Well, if you didn't pay rent for April, May, June, July, and August, what were you doing?
Waiting for him to pay his rent because I couldn't afford to pay for my station.
Just a second.
Yeah.
You didn't pay any rent. You didn't say to the landlord, I have a roommate. I can't take care of him. I'm giving you my half of the rent.
Well, I know there's a moratorium for COVID, and the government shut my business down.
That's what he says.
I knew that I had protection.
That's what he says. He's saying the exact same thing you are in his answer.
Did he go to court and do the paperwork and do the filings and
Who cares?
And I do.
Who cares? I don't. Each of you seems to be living. You operate your hair business out of your house.
In addition to
Just
another business, yes.
Whatever. You operate your hair business out of the house. He operates, I don't know what he does, but I know he's 32 years old, supports himself, spends $700 a month on a car, spent for a long time $1,200 a month rent, and can't remember the last year or the last decade that he filed tax returns. So whatever it is, this is your problem, Miss Birkeland, and this is what I actually didn't understand when I read your complaint, because what you're looking for is 8 months' rent from him.
Correct.
You didn't pay the rent.
I shouldn't be evicted. I asked him to leave every month that he didn't pay me.
Should have read a cutter.
I had a business as a hairdresser, and I went out to rent a station, and I was out for 4 months to pay for a station.
It doesn't
because
matter.
I wanted to go back to be my nice space that I had created for myself and I've worked my butt off for, and my clients liked. I wasn't getting paid rent for his room. I wanted to move my studio into his room and make it my hair salon. So I can have 2 businesses now out of my home. I have 0 income, 0 businesses. My life has not been easy, and this home was the one thing that I've worked my ass off for. It's the only thing in life that I loved, besides my
Miss Birkeland, did you say to your landlord,
yes,
I have a roommate.
Yes.
He's not paying me his half of the rent, but I want to show you in good faith, I am going to give you my portion of the rent. You didn't do that.
Yes, I did, Your Honor.
Well, show me. Just a second. Show me. All I know is they say this is your evidence for the full amount of the rent for April and May. And I know you didn't pay June, July, August, and September. I know you didn't pay that. So I'm asking you, just show me some proof, Miss Birkeland, that you said to your landlord, who is also in business of renting space for which they are requesting rent paid in a timely fashion, and then they've got 2 people who decide, well, we have a rent moratorium. I'm not in any worse position now than before, so I'm just not going to pay rent.
Your Honor, I was...
Just show me that you made partial payment to the landlord for April, May, June, July, and August.
I don't have that because I was protected under the law.
Okay, good. And so is he. Case is dismissed. We're finished. Goodbye. Goodbye. Listen,
I can prove
you
to
two
you
are so.
that
You're
I
just.
attempted
You're
to
just.
pay full rent. After
You
he
two.
was gone, and I was able to bring my business into the house.
You two are soulmates. You both relied.
No, Your Honor, I'm sorry.
Out.
This court is adjourned.
Soulmates. You both took advantage of a law, and you both lost. Goodbye.
I have nowhere to operate both of my businesses. I created one during COVID.
We both exercised our rights under California tenant laws.
Which I would have had I had a room that he wouldn't leave.
You know, that's just what it is.
Every month I pleaded with him.
That never happened.
I cried, I fought.
She never asked me to leave crying, approached me, or nothing.
If it can be helped, don't have a roommate.
I'm glad you didn't give her any money. But if you were going to award any money in this case, it should go to the landlord, because the plaintiff did the exact same thing using the exact same legal loophole that was created during COVID for people who really were struggling and not being able to afford their rent. And now she sues him for doing the exact same thing that she did. So the landlord is really the only one out here.
That's correct.
Yeah.
And if you could write a check to the landlord, that would be fine. But the landlord isn't a party. I have a feeling that there are a lot of very small landlords, you know, not people that own giant buildings, but people who have, you know, their real estate businesses are small. They may have 2 or 3 or 4 apartments that they rent. They maintain them, whatever. She was living there for a while, clearly happy with the situation because she lived there for 5 years. Well, why just not pay your rent if you're still doing hair in the apartment? That's a business. That's what you're doing. He's still collecting his same royalties, which you think somebody else should be reporting on their tax return. I don't know. People have to really grow up. I'm getting so... I'm losing my patience so quickly.
Maybe I'm losing it a little young.
Maybe. I think I'm...
Isaac Uno is suing his former tenants, Ann V. Kelly and Kevin Jackson, for unpaid rent and property damage.
Court come to order. All rise.
Have a seat, please.
Hello, Judge. Case number 2116, Uno versus Kelly Jackson.
Thank you.
You're welcome.
Mr. Uno, you purchased a duplex home, 2 different apartments.
That's correct.
In what month and year did you purchase the home?
November of 2020.
And when you purchased it, one of the duplexes was occupied by the defendants.
That's correct.
It is your claim that they owe you for rent
Yes.
and for property damage.
That's correct.
They are no longer there.
No.
Mr. Jackson?
Yes.
How long were you and your wife living in the duplex before November of 2020?
We moved in June of 2019.
And at the time, do you recall who your landlord was in June of 2019?
Yes.
Between June of 2019, when you first moved in, and November of 2020, when the plaintiff bought the property, was there any work done on that property?
Not at all.
No maintenance?
No maintenance.
Okay. So from the time you moved in, the prior owner did no maintenance on that property, did no painting?
Just the minor stuff before we moved in. They just painted and you just had everything looking nice, the floors.
So just a second. So the prior owner painted the premises and did the floors?
Yes, it was carpet and some flooring in the kitchen.
And Mr. Uno did not do any other painting or flooring or any cosmetic work on the duplex when he purchased it in November of 2020.
No.
So whatever was there by the previous owner of the property is still there.
Yes.
I'm just asking you this because your counterclaim is for child endangerment, and the child endangerment is because of lead paint. That's what you write here.
Yes.
He didn't put in the lead paint, right?
Yes, thinking about that.
He didn't paint it. You don't know when it was painted. Maybe it was painted by the prior owner. How do you know? By the way, do you have medical records of the child that you claim has lead poisoning?
Yes.
I'd like to see them. Yes, you. I have no idea what this says.
That's the piece of paper that he gave me from the hospital.
Well, I don't understand.
For the blood work.
I'm not a doctor, so I can't.
Okay.
We have something from the health department also stating that because my son his lead was found in his system, they got involved.
I understand that. He did not paint the apartment.
No, ma'am.
When you, just for my own curiosity, when you bought this place, do you remember the purchase of it? And when you purchase a property, usually there's an inspection.
Yes.
And one of the questions usually has to do with lead paint. Do you remember any of that from when you purchased the property?
I didn't receive any notification of lead paint from the inspectors.
Well, usually they sign off that there is no lead paint.
I don't remember seeing because they never mentioned anything about it.
Nothing about lead paint? No. Okay. Did you ever have the home tested, by the way, for lead?
Only when we found out about my son having lead.
Okay. And do you have the test result?
And there was lead found in 2 places, not just the bathtub.
Miss Kelly, the issue is he didn't do any of that painting.
Right.
He bought the place. You had been living there for a year and a half before he bought the place.
Right.
Right?
Yes.
Okay. And your son was born within that year and a half.
Well, we moved there, he was 6 months.
He was 6 months old, so he lived there for a year and a half even before he purchased it.
Yes, ma'am.
Okay.
We did buy the things to fix the bathroom up. He told us to take them back to fix the tub and everything because we asked him to fix it. So the things we had, like to get the tub fixed, the flooring and everything, he told us to take back.
How many people were living in the duplex?
In our apartment?
In your apartment?
4.
4? Mm-hmm. Including the baby?
Yes, ma'am.
Including the baby. And how old's the other child?
She's 14.
Okay. Do you have that report?
No. This is just stating where it was at.
The health department?
Yes. I thought that piece of paper that I gave you was that one.
No.
This is just.
This doesn't say.
This is just showing where the lead was found in the house.
How old is this duplex?
It was built in 1906, so almost 115 years or so.
Yeah. And they certainly used lead paint
Possibly,
then.
yeah. I'm not sure about
I'm
it.
not sure.
I don't
But,
understand about it.
Ms. Kelly, Mr. Jackson, that's not his fault. That's not his fault. So now I would like to know, Mr. Uno is suing you for rent. And I'd like to know first, how much rent were you paying?
$750.
And that's what you were paying under the old lease?
Yes.
And were you current on your rent when Mr. Uno took over the property?
Yes.
In November of 2020?
Yes.
So far correct?
That's accurate.
When did you stop paying rent?
December of 2021.
So you paid rent for a year?
Yes, ma'am.
Were you working, Mr. Jackson?
Yes, when I first moved in, yes, I was working 2 jobs.
And were you working from November of 2020 to December of 2021?
Yes, I was.
For whom?
Yes, I was. I was working for TGI Fridays.
And Ms. Kelly, were you working?
No, ma'am, I'm disabled.
And how much were you receiving in pay?
I was only getting...
If you have to think about it, you don't remember.
Yeah, I wasn't getting too much because it was during COVID, and I was working at a restaurant, and I was only allowed to work 3 days out of the week.
Okay. And what happened in December of 2021?
What happened was he already sent us a letter previously saying that he wanted to go up on the rent to a...
Okay.
Yes, to
so you
$1,000.
had no lease anymore, and he wanted to raise the rent.
Mm-hmm.
Okay. I believe you. And that was the reason that you used to try to evict them before?
Yes, that was the first one. But I don't agree with his statement.
Well, what statement don't you agree with?
Isaac Uno claims his former tenants, Ann V. Kelly and Kevin Jackson, owe for unpaid rent and property damage. Ann V. and Kevin are countersuing for child endangerment and a constructive eviction.
And in what month was that?
He sent it to us, I want to say...
Do you remember, Mr. Uno?
It was 90 days before the 1st of December, so that would have been, I think, September 31st or October 31st. Maybe.
That he was raising the rent to what?
To $1,000 a month.
Effective December.
Yes, December 1st.
And what happened in December?
We were, at that time, looking for a new apartment, and at that time it was hard because around that time, a lot of the rent was going up from just being like $800, $900 to like $1,200 to $1,400 for rent for a month there.
Don't speak.
Okay.
And that was, why we stopped paying rent, because we were actually looking for a house, even when he gave us the 90 days.
Okay. So, Mr. Jackson, based upon what you just told me, so stop shaking your head, based upon what you told me, your landlord gave you 90 days notice that if you wished to stay on, he was raising your rent to $1,000 a month.
Yes.
And you started to look around for a new place.
Yes.
And the new places were very expensive.
Yes.
And you didn't find a place.
No.
So you decided to stay in this place.
No.
So what did you do?
We...
So if you didn't find a place
we decided,
in December...
We were trying to stay there until we found a place.
I assume they paid rent in September.
Yes.
Oh, yes.
In October?
Yes.
Yes.
They paid rent in October?
Yes.
Good. And November?
November was the last month that they paid.
So they paid in November?
Yes.
So you stopped paying rent in December of 2021?
Yes.
No, you cannot.
Okay.
If I need you,
Yes,
I'll
ma'am.
come to you.
Okay, yes, ma'am.
Okay?
Okay.
Because so far he's doing fine. You stopped paying rent in December of 2021. Tell me why.
We didn't want to live there ourselves anymore either, but it was just a lot of things going on at the house. Like after my father passed away, and he first gave us the first eviction notice because he gave us more than one.
Just a second.
Okay, I'm sorry.
We're skipping over.
Okay.
He didn't give you an eviction notice, I assume, until you stopped paying rent.
No, before December, he gave us like 3 of them, I think. I want to say 3.
Really?
Yes.
Why were you trying to evict them before?
They had torn up the carpet upstairs. It was a moratorium for evictions, but there was a stipulation that emergency evictions for nuisance tenants could be granted before then.
Is there any reason why you took up the carpets?
Yes, the same thing before he took over. Everything was in the house before that, and we complained to the previous owner that the carpet was already dirty. They said that they were going to come and shampoo it, but never did. Like, we would walk and our socks would be black, our feet would be black, so we wanted to take the carpet up. It was dirty to us. And I myself actually told him about it. I went downstairs to his apartment because he lived downstairs from us, talked to him about it. He came upstairs, and I showed him a section of the carpet that wasn't even connected to the floor. You can lift up the whole carpet and like across a whole section of the wall. And then when I did that, he seen that the hardwood looked kind of decent, and then instead of putting new carpet on, he wanted the hardwood to get sanded down and just get stained and and lacquered over.
So you took the carpet off?
Yes.
I believe you. Sounds right, Mr. Uno. Okay. And that was the reason that you used to try to evict them before?
Yes, that was the first one. but I don't agree with his statement.
Well, what statement don't you agree with?
Well, a number of things that he said. I didn't authorize him. We spoke. I asked them in the first meeting if there was anything that they wanted to have spruced up or anything as a good gesture, and they took it upon themselves to take up the carpet without my permission.
Okay, not a huge deal. Not a huge deal. You can use it as a huge deal if you want your tenants out because you know you can re-rent that duplex for substantially more money.
It was more about their conduct, that they were being very disturbing behavior and just being off the wall. So I wanted them out for a lot of reasons.
Well, I know, but only one of them qualified under the eviction moratorium.
Yes, for emergency of dismantling the
Only
place.
one, and that would have been the carpet. Okay, Mr. Jackson.
Yes.
I'm back to you, sir. I haven't figured out yet. You stopped paying rent in December, and you moved out in what month?
We didn't move out until June.
June. So January, February, March, April, and May. Let's say 5 months' rent that you didn't pay, correct?
Yes.
Why?
Can I speak, Your Honor?
Just, no, him. Tell me why you didn't pay the 5 months' rent, Mr. Jackson.
We just figured that, well, we didn't figure. We didn't want to pay him $1,000 because to us,
Okay, so
we felt
let's
that-
say you didn't want to pay him $1,000, even though you just told me finding another place would be more expensive, right? You said $1,200, $1,400, but you didn't give him $750. You gave him $0 for those 5 months. So I'm going to come back to you, Mr. Jackson. Does your wife receive disability payments because of her disability?
Yes.
Yes. How much a month?
That I don't know.
How much a month do you receive, Ms. Kelly?
$1,000.
$1,000. And did you continue to receive that $1,000 every month from December until June?
Yes, ma'am.
You see, certain things remain constant. Your disability payments remain constant.
Right.
If you live in an apartment and you have the same sort of income, then you pay rent.
Right.
And if you didn't pay $1,000, so I hear you. Well, that's what he said he wanted. And he's the landlord. And he's allowed to do that if you're going to stay in his premises. But you paid nothing, Mr. Jackson, and that's what I don't understand.
Well, the furnace was busted.
Just a second.
Yeah.
Miss Kelly.
Sorry, I'm sorry.
What? You paid nothing.
Yeah, nothing.
Where did you move in June?
Moved in the same area, like kind of like probably 10 minutes away from that particular street.
Is it a private house or an apartment?
It's a house. Well, it's a duplex as well.
Duplex. So the same sort of setup. And how much rent are you paying?
Pay $950.
So almost as much as he wanted in his rent. But are you more comfortable in that unit?
Yes.
Okay.
My wife walked down there and asked, was he the landlord? He just said that he was the building manager. So nobody even got rent for the month of November when we lived there, not him or even the previous people, because he didn't even come upstairs and introduce us.
Well,
But,
I wouldn't complain about that, sir, if you're ahead of the game so far.
Isaac Uno claims his tenants, Envy Kelly and Kevin Jackson, owe for unpaid rent and property damage. Envy and Kevin claim Isaac forced them to leave.
Now, you saved over 5 months, let's say minimally $750.
$37.50.
$37.50. Now, Mr. Uno, the only question that I have to ask you is, Mr. Jackson and Miss Kelly say that they filled out some sort of forms for rent relief during COVID, and you signed it. And they say you received money from the state for any unpaid rent. Did you receive any money from the state for rent that they didn't pay?
No, I approached them with an application, but the program that funds the landlord relief for the moratorium was only open for 1 month, and I came and went, and I missed it, and I never got it. So I did have them fill out something. It was just a hardship thing, but they didn't give me the money for it. I never received anything.
So you didn't receive any money. So far, Miss Kelly and Mr. Jackson, you owe Mr. Uno $3,750 for rent that you didn't pay while you occupied his premises. You, your furniture, your children, I don't care what it is. That's what you didn't pay. And you can't save up your money and not pay your landlord. That's his business. Just like you work for Fridays and you get your pay when you're supposed to, that's his business. He bought a house. He was counting on the income from that house to pay some of his expenses, and you didn't pay it. Well, there's no question you have to pay it. Now you have a counterclaim. I've already gotten rid of child endangerment. This is 150 years old. Constructive eviction. So I'd like you to tell me your allegations of constructive eviction.
Is that like from him not doing anything to the apartment while we lived there?
I assume. You say you were constructively evicted.
Yes, he...
But you didn't leave.
Yes, he has a couple of text messages in here where he says that he actually came up to the apartment to check things. He brought up when he first got there in November, we didn't have a working toilet until...
Just a second.
Oh, yeah, I'm sorry.
So before he bought it, is that what you're telling me?
I mean, not before, I'm sorry. When he got the apartment in November, the previous owners, we were trying to contact to see who we pay for rent.
Just a second.
Okay, yeah.
He bought the duplex in November of 2020.
Yes.
Is what you're telling me, Mr. Jackson, that certain things weren't working prior to his purchasing the property?
No, I'm sorry. I want to take that back. After he purchased it, we didn't even know he purchased it because he was living downstairs, and my wife walked down there and asked, was he the landlord? He just said that he was the building manager. So nobody even got rent for the month of November when we lived there, not him or even the previous people, because he didn't even come upstairs and introduce us.
Well,
but,
I wouldn't complain about that, sir, if you're ahead of the game so far. If you didn't pay rent for November. You didn't pay the prior landlord and you didn't pay him. So far you're ahead $750. Okay, keep going.
To go back to the November, so during November, our toilet got stopped up, like right before Thanksgiving.
So shortly after he purchased it, he hadn't been up in the apartment, right?
No, not
just
at all.
you, your wife, your teenage daughter, and the baby.
Yeah, and the kids.
Okay, and the toilet got stopped up, and
he brought in a plumber, and then the guy found out that my son put a little toy in there, and he actually got the toy out.
So the toilet was broken by your son. Okay, so now the plumber said, here's the toy. Kid threw a toy down the toilet. Not an unusual, and
then the very next month in December, my son didn't put anything down there. The toilet started acting up again. It wouldn't flush for like all the way up until the next year, and it never got fixed. But it was from...
Well, you had to have, sir, you lived there with 3 adults. So there had to be a functioning toilet in the house.
It wasn't functioning.
So where did you go to use a functioning restroom?
Her mom lived up the street from us, so sometimes we lived up the street, or sometimes we would just still use the toilet.
Okay. You owe him $3,750 for rent that you didn't pay. Counterclaims dismissed. We're finished. Thank you very much.
This court is adjourned.
I had to collect monetary judgment to the courts.
Him being the landlord, he left us like living in crappy conditions.
It was a unbearable situation that I was going through with the noise and the disturbances.
Yeah, he never came up there at all to fix anything.
And the destruction of the property.
He just started making up so many rules, to make it uncomfortable for us to live there.
Oh, it was, it's pretty quiet now.
That man is crazy. I'm glad it's over with.
You know what I think is interesting, Sarah, with these cases, we've had a lot of them. The forgiveness that the government wanted to show to people who were having trouble during COVID, work-related trouble, didn't have the same income, and didn't want to have a whole bunch of dispossessed homeless people. It came from a good place, as did some of the monies that were sent out by the government to sort of help people over a difficult time during the height of COVID. But then there are other people who suffer as a result of that, like a landlord who buys a property, a duplex property. Part of it is for income so that they can pay off mortgage, taxes, lawn service, whatever you have to pay on a house. And then the defendants, who really had no changed circumstances that they indicated to me. He was working, she was getting whatever she gets from disability, which is not insubstantial. I don't know if they get any other assistance for any of their other children, but certainly they moved into a place that's more expensive now, that's not far away. They just decided not to pay rent. And I don't think that that is the spirit of what either the federal government or the states who enacted it meant to happen, because the plaintiff owner of this property has rights too. You've taken away a right of his.
I agree To an extent, but I also think that that's more a problem on the government's implementation of the moratorium in the first place. That's what ended up hurting the landlord. These people were simply taking advantage of a legal loophole that was created for them. He was in the restaurant business, which, as we know, was one of the toughest hit by COVID.
Right.
She was on a fixed income that wouldn't be enough to cover, well, barely enough to cover the rent on its own. And then they have to support themselves, feed themselves. They have 2 children. So I'm sympathetic towards the taking advantage of a legal loophole. So I don't know, if I was in your position, I might have decided differently.
Okay.
But that's okay.
All
We
right.
can agree to disagree.
That sometimes happens.
Vanessa Howard is suing her former friend, Ontrell Brooks, for a car loan.
Court come to order. All rise.
Have a seat, everyone.
Hello, Judge.
Hello.
Case 2108, Howard versus Brooks.
Thank you.
You're welcome.
Ms. Howard, your case is simple. You claim a loan to the defendant for the down payment on a car.
Yes.
When did you make this loan?
March 24th of this year.
How much was it?
I gave him $1,500 and he paid $300.
Where did you take the money from?
I had it at my home.
In cash?
Yes.
What kind of work do you do?
I'm a hairstylist. I'm an owner-operator.
Okay.
Yes.
And that's the sole source of your income?
Yes. I own a salon business. I'm opening my second one.
Tell me how you know the defendant.
He was a client of a former stylist many years ago, so I met him through the salon.
Did you have any sort of relationship with him?
At the time that I met, no.
No. At the time that you gave him this loan,
we were friends.
What did he say he needed the loan for?
To get a vehicle.
To get a car?
He was at Mercedes trying to purchase another car, and I knew he had a baby on the way, so I felt it was...
I want to know what he said to you.
He said that he needed help with the down payment. He was short some for a down payment on a car that he wanted.
Did you have that conversation on the phone or in person?
Yeah, he called me and asked me for originally $2,500 to help him with the down payment. And I told him, well, I don't know if I have that much. I'll see what I can get him. I had the $1,500. He came to pick it up at my home.
And that was on the 24th of March?
Yes.
When did you purchase your car?
I believe it was the 24th as well.
Do you have any paperwork for the car? What paperwork do you have there? I just want to see what you brought with you today.
Basically, the lien holder paper.
And what is that supposed to tell me?
I believe it has the date on there when I purchased it.
Okay. And how much did you put down on the car?
$9,000.
Did you trade in a car?
No.
Why did you need $2,500 from her?
I actually didn't ask for it. I just mentioned to her that I
No, well,
needed
just a
it.
second. I asked you a question.
Okay.
Why did you need extra money towards the down payment? Did it affect the payments? Did it affect the insurance? Did it affect the
yes.
premium?
Basically, the car, it was like $74,000. So if I was to put down a lower payment, like you were saying, the payment would be higher for the monthly. So if I put down a little more, it dropped it down a little bit.
Yeah.
Yeah. Yeah.
So she gave you $1,500, not $25.
Yes.
But she gave you $1,500.
Yeah.
And she gave that to you around the same time that you purchased the car. Were you current in your insurance payments on the car?
Yes.
And then you crashed the car.
Yes.
And the insurance company paid the lien holder on the car.
Yes.
Made the payout.
Yes.
So you didn't get any money from the insurance.
No.
So now you have no car, right? I don't know if you have a car
I
now.
have a car, yes.
Well, you got another car.
Yes.
What kind of car did you buy?
Tesla.
A Tesla. And how much did you pay for the Tesla?
I put down like $8,000.
Where'd you get the $8,000 from?
I work. I have a place where I hold traveling nurses.
Did you take the money out of a bank, or did you have it in cash?
I had it in cash.
The $8,000.
Yeah.
How much money do you make from this business that you have?
It varies depending on how many nurses I have staying there.
So you own the property, or do you manage the property?
I manage the property. So it's basically housing nurses or people that travel for business.
And how long have you had that business?
I've been doing that for maybe a couple years now.
That's how you support yourself?
That, and I do training as well, fitness training.
Okay, so now you paid back $300 of the $15, right?
I gave her $300.
Right, and when did you give her the $300?
I'm not quite sure the date, but...
Give me a month.
I'm not quite sure.
When did he give you the $300?
May 17th.
Okay.
Tell me why you gave it back, the $300.
I gave it back to her because she basically
Not basically. This is basic.
Well, because she kept asking for it. So just to get her off me for a second, so I gave her $300. Just I didn't feel like I owed it to her because I thought that, you know, it was given to me because we were like really cool.
Just a second. Okay. All right. Well, Miss Howard.
You can't be serious.
Miss Howard.
Yes, ma'am.
How long have you been operating your 2 salons?
I'm opening a new one now, and the first one was opened in 2012.
Do you live with anyone?
My children.
How many kids do you have?
I have 3.
How old are they?
I have a 17, 18, and 21-year-old.
Big kids?
Yeah, college and high school, yes.
Who supports them?
I do.
From
Their
your
father
work?
helps too, yes.
From your work. Do you live with their father?
No.
No. But he also helps.
Yes, he does.
And you sound like a really intelligent, put-together woman who's had her own business, who's got 3 kids, college kids.
Yes.
Moving forward.
Yes.
Why? Why do you think, you know, I know that you work, because if you're a hairdresser and that's your source of income, you work really hard. It takes a long time to accumulate $1,500. You know, I'm sure you get some tips and stuff. That's the cash that you keep.
Yeah.
So you work hard and you've got 3 kids who need money. He wants to buy an uber expensive car and he wants his payments to be lower. So he says to you, not that he needs it. See, he doesn't need it to get a car. He wants it to make his payments lower.
That's not how he presented it to me.
How did he present it to you?
He said he needs help, he needs the money for the down payment, and he told me that, you know, the situation, his car got taken away or whatever. And
his car got what?
His previous vehicle was taken from him.
From how?
I don't know.
What kind of a car did you have? Before you bought the BMW?
That's what it was. It was a BMW.
Oh, and then you bought a Mercedes?
Yeah.
Okay, so you bought, sorry, I got that confused. You bought the Mercedes using some of her money. Before that, you had a BMW.
Yes.
Okay, and now you have a Tesla. Do you understand how foolish that sounds?
Yes.
You don't want to sound foolish.
Well, like I said, he's had a baby on the way any day now, and my compassion for the situation, I was like, okay, I'll give you that. And I know he's had a source of income. It's not like I've ever known him not to have an income. So I felt like, okay, he'll do right by me. Of course, he didn't. We see.
Do you know how many people stand in exactly that spot and say, you know, I trusted him. He gave me this story, gave me that story.
Yes.
And what I'm telling you is most of the people standing there, for some reason that has always baffled me, are women. Any guy who takes money from you to lower his car payment and buys a car for $75,000, the only people that do that sort of thing are untrustworthy. Then you change the contract and you said, not acceptable. You're behind $500 and a late payment will only be acceptable with a current payment. Is there anything about that in your contract?
There's not.
Okay, so if it's not in your contract, it doesn't exist.
Vanessa Howard claims her former friend, Ontrell Brooks, owes for a car loan.
Most of the people standing there, for some reason that has always baffled me, are women.
Yeah.
Very rarely do I have guys standing there and say, you know, she asked me for this, and so I knew she had a baby on the way, and I felt sorry for it, so I gave them money.
Right.
Most of the time, they say goodbye, which is what you should have said. And
absolutely.
You appear to be much too fine a lady and a hardworking lady. Don't give anybody.
No more.
Any guy who takes money from you to lower his car payment and buys a car for $75,000 and asks you for $1,000 or $2,000, knowing that you're a working gal and that he didn't need it to buy a car. He could have bought a car for $50,000. He could have bought a car for $30,000.
Right.
Likes to drive fancy cars with somebody else's money, okay?
Yes.
So the only people that do that sort of thing are untrustworthy, usually, as my great-grandmother would call them, bums. So I would suggest that you be smart in the future. You're a hardworking lady. Hold on to your money. If you want to invest in anything, invest in your children's future. We're done here. Judge complaint.
This court is adjourned.
Mr. Brooks took my money with no intentions of paying back.
I thought it was, she gave it to me.
Oh, car crashed, my tires got slashed.
I thought it was a gift because she really liked me.
Don't let men borrow money.
Lovely woman, hardworking woman. She's going to have a chain, as Dolly Parton would say, have a chain. Going to have a second salon. On the other side, you have somebody with zero judgment.
He's well versed in other people's money.
Why a perfectly sensible, bright woman would take money that she worked really hard for and give it to somebody that she hardly knows.
Women have to be smarter.
The women have to be smarter, worry about themselves.
Yeah.
Case 2113, Pickett versus Glick. All parties, please step forward.
William Pickett is suing his former friend, Clinton Gick, for unpaid car payments and vehicle damage.
Mr. Pickett, you and the defendant, according to what I've read, were friends. You knew each other.
Yes.
You had a car that you were interested in selling. The defendant was interested in purchasing the car. Your car was 10 or 11-year-old vehicle,
Correct.
is that correct?
Yes.
When had you purchased it?
I purchased it about a year or so prior.
So you only had the car for a year. You were not an
Sure
original
enough,
owner.
yeah.
Did you pay cash?
I did.
How much did you pay for the car?
Roughly $10,000, $10,000.
No, I want to know. I mean, you came to court today, not a roughly. Today we know the numbers. We're not talking about something that happened 20 years ago, something that happened a year ago. You bought a car a year ago. You paid cash for it, according to you. I want to know how much you paid for it. That's easy. You should have those records.
$10,000.
Well, now you say 10, right?
Yep.
Now you say 10. So now I'm going to tell you to go outside and get me the bill of sale for the car.
I did not bring that.
Why?
I didn't think I needed it.
How am I supposed to ascertain what you paid for the car, sir?
I didn't think about that.
Should have thought about it. I thought about it right off the bat. You had the car for 1 year. And when did you sell it to the defendant?
3/18 of 22.
For how much?
$10,000.
Well, then you're a genius businessman, because unless this 10, 11-year-old car, Mr. Pickett, had something really unusual about it, most cars depreciate the moment you drive them out of a lot. You bought this car from a company, which means you paid more for it than if you purchased it through a private person. You understand that?
Yes.
Of course. So there was clearly a markup. Sarah, take a look at a 2012 Dodge Charger with 148,000 miles.
I got it. Between 7,500 and 10,000 for a private party sale.
Okay, so as I thought, the value of the car went down from when you bought it, but you sold it to him for $10,000 because he was making payments, I assume because he was making payments. Did you have a written contract?
I did.
I'd like to take a look at it. Mr. Glick, how did you know each other, sir?
We worked together. We'd known each other for about a year, I think, at the time the car was sold.
Okay, so the first thing was he traded in something of value, which was he gave you a car.
Correct.
What kind of car did he give you?
A Honda minivan.
Did you have the title to that?
Yes, I did.
Did he turn over the title to you?
He did.
What did you do with the Honda minivan?
I sold it.
To whom?
Someone off of Facebook Marketplace.
Okay, when did you sell it?
A few weeks afterwards.
How much did you sell it for? How much did you say you sold it for?
$1,000, $1,200.
Let's get specific, Mr. Pickett.
$1,000.
I'm not exactly sure what he sold it for, but clearly acknowledges at least $1,000. So this is what the lawsuit is about, and I've read your contract. According to the contract that you have here, you listed the dates, the schedule of payments, and you marked off when he paid and when he didn't. But we're going to go through the dates, and your lawsuit seeks damages to the car, repo fees, the unpaid contract price of the car because you repossessed it and you want him to continue until he's finished paying for it, right? That's what you want.
Yes, ma'am.
And the defendant has a counterclaim. And his counterclaim, in effect, although he doesn't articulate it in legalese, the basis of his countersuit is that there was never any meaningful breach of the contract and that he tried to make his payments pursuant to the contract and that you repossessed the car without just cause, and he's counterclaiming for the money that he put into the car as equity. That's what your counterclaim is.
That's
correct? Okay. So far you put in $4,000. According to this, he paid you March of 2022, April. As a matter of fact, he made 2 payments.
Correct. Payment schedule was for every 2 weeks.
6/17, he made a partial payment, but made that up on 7/1, so he was up to date. Then you say on the 15th of July, he missed a payment. Did you miss a payment the 15th of July?
Yes, I did, Your Honor.
Tell me why.
At that point, the plaintiff had already threatened to repossess the car several times before I'd ever missed a payment. on the car.
Because you made a partial payment once in June.
Yeah, and also.
But then made it up again within 2 weeks.
Yes, exactly.
Okay, so you had already said to him, you missed payments, I'm going to repossess the car.
I informed, I didn't threaten to repossess it.
No.
Yeah, yes.
Yeah.
Yes.
Okay, so you missed a payment on July 15th.
Yes, and I informed him when I missed the payment that the reason for missing it, he had just filed for bankruptcy, and with his bankruptcy and the threats to repossess the car, I had decided that I wanted to miss, as it states in the contract, that I could miss 2 consecutive payments before repossession. I wanted to talk to a lawyer and make sure that I wasn't going to be putting even more money into a car
that you weren't going to have equity in.
Exactly.
Okay, so that's why you missed July 15th.
Yes, that's
okay.
correct.
And it's the 29th of July also missed.
Yes. So I attempted to give Mr. Pickett a $500 payment on the 29th. He refused to accept that payment, and I have that in text.
I'd like to see it.
Text messages.
I'd like to see it. Do you acknowledge that he attempted to give you a payment on the 29th?
Yeah, he attempted to make a partial payment.
He attempted to give you $500.
Correct.
And tell me why you didn't accept the $500. He missed the payment on the 15th.
I informed him on the 16th that I would not accept a late payment unless it's in conjunction with the current payment.
You can't change the contract, sir. You can't change a written contract. There was a loan on this car.
Yeah, there's a title loan on it.
Oh, you didn't tell me that. That adds a different wrinkle to this whole thing because you told me you paid cash for the car, so I assume there was not a problem.
William Pickett claims his former friend, Clinton Gick, owes for car payments and vehicle damage. Clinton is countersuing, claiming William sold the car under false pretenses.
No, you had a written contract with him. If you're changing the terms, he has to agree to the terms in writing in the same force and manner of the original contract, which is this in writing signed by both parties. You have a contract here. The contract says he can't miss 2 consecutive payments. He wasn't missing 2 consecutive payments. He missed July 15th, and he tried to give you one on the 29th of July. If you refuse to accept it, he hasn't missed 2 payments. You refuse to accept the second one. Got it?
Got it.
Okay, well, I see the interchange, Mr. Pickett, and the interchange clearly says you're paying your $1,000 today or returning my car. He says, I'll be giving you my $500 payment that's due today. Then you changed the contract and you said, not acceptable. You're behind $500 and a late payment will only be acceptable with a current payment. Is there anything about that in your contract?
There's not.
Okay, so if it's not in your contract, it doesn't exist, and you had so far no reason to repossess the car. Did he try to make a payment to you in August?
I think one other time between the time I repossessed it.
Okay, well, you had no reason to repossess it so far unless he missed 2 consecutive payments or unless he failed to keep insurance. Did he fail to keep insurance?
I have never been given proof of insurance.
This doesn't require that you are given proof of insurance.
Or not.
This doesn't say you require proof. Did you have insurance on the car?
Yes, I did, Your Honor.
Through whom?
Erie Insurance Agency.
Okay, and you have no information to the contrary?
I don't.
Okay, fine. So at the time you repossessed the car so far, Mr. Pickett, you didn't have basis under your contract to repossess the car.
There was also other terms that I believed he had violated.
Well, let's hear them. So far, he didn't miss 2 consecutive payments. Had you filed for bankruptcy?
I had started filing for bankruptcy, yeah.
Is that completed?
Still hasn't been discharged yet. I think I have another month or so.
Was this the first time you filed for bankruptcy? Yes, buyer misses 2 or more consecutive payments. Buyer fails to maintain full coverage under insurance, any significant damage to the vehicle that is not repaired in 30 days. Did you notify Mr. Glick of any damage to the car, give him notice, and say, pursuant to the contract, it has to be fixed in 30 days?
We had talked about it when he came to drop off one of his payments, and he said...
Well, give me a month.
It was...
A month and a year.
It was in June.
June of 2022, he came over to drop off a payment, and that would have either been on June 3rd or June 17th. Correct. Okay, and tell me about the conversation.
I said, hey, there's a dent in the front now. He said he'll get taken care of. At that point, I didn't really inspect the car because...
Well, I don't care what you didn't do. Yeah. I want to know what you did.
Yeah, I told him, it needs to be fixed. And he said he'll get taken care of.
Okay, and?
When I repossessed it, it was still there, as well as more damage.
Okay. Did he talk to you about the dent in the front?
I don't recall that conversation ever happening. There was text messages sent to me about damage to the car. The car had dents and dings all over it when I got the car. I mean, the front bumper even had significant damage to it.
You repossessed the car at the end of August. Where is the car now?
At my house.
What's it doing at your house?
I was just sitting there for the moment.
Well, what's your intention to do with the car?
Give it up in my bankruptcy or repair it and keep it and pay it off.
Who has the title?
The title loan company.
So there was a loan on this car?
Yeah, there's a title loan on it.
Oh, you didn't tell me that. That adds a different wrinkle to this whole thing, because you told me you paid cash for the car, so I assume there was not a problem. When did you take out a title loan on the car?
I took out the title loan.
Month and year?
One of them was in December of 21.
Did you know that there was a title loan taken out on this car?
I knew that there was one. I didn't know that there were multiple. I don't know. But yeah, I did know there was a title loan.
Did you know in what amount?
No, I was never.
Well, that's pretty dumb of you.
Yeah, I agree.
Well, because if you're buying something free and clear that he owes nothing on, that's one thing. How much was the title loan?
Roughly $6,000 is what was owed on it still at that point when he bought it.
How much did you pay off?
A few thousand by that point. It's super high interest.
Okie dokie. Mr. Pickett, your claim against the defendant is dismissed. I'm now entertaining his counterclaim. Do you understand?
Yes, ma'am.
You get stuck with this car. Now, problem is, you drove this car.
Yes.
Was it your primary source of driving the car?
Yes, it was.
Okay. For 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 months, right?
Yes.
Okay, so, Mr. Glick, this was your primary vehicle. How much do you think it would cost you to rent a car per month? Per month. Give me a figure.
To rent a car?
Yeah.
Per month, I would say $900 a month, probably something like that. $900,000 a month, maybe.
Okay. Based upon what you told me, it's not so egregious because you had the use of the car for 10 months. I actually don't think that an 11-year-old car would cost that much to rent. $900 a month, considering that you also paid for your own insurance.
Correct.
And if
Correct.
you rented a car, that the insurance would, of necessity, come with a car. Sarah, could you look up for me best deals on leasing a Dodge Charger? I don't know what that is. Is that a truck?
It's a car.
Is there a site where you could look that up?
I'll see what I could find.
But the intention was that money was going to go towards, something that I would own.
Well, I understand that,
right.
but you had full use of his property for 10 months.
Sure.
You don't think it's fair for you not to pay for some of that use?
I would think the depreciation in the car for the mileage that I put on it would be more than fair. Absolutely.
Everything depends on how much you put down versus how much you pay monthly, so there's a wide
range. Give me the range. He didn't put anything.
$786 a month, $843 a month, but these are for brand new Dodge Chargers, not for 2012.
Oh.
So.
Okay. And according to you, the current low price on this car is $7,500 price.
For a private party.
For a private
yes.
party, low price, $7,500.
Yes.
So you're going to resell this car, and the car is currently in working order, and the low price on that car is $7,500, right?
Yes.
And he's already paid you $5,000.
Yes.
In order to break even, if you sold that car, all you need is $2,500.
Correct.
So I think that it's more than fair to give you credit for the $2,500 from what you paid.
Okay.
You paid $5,000. Half of that seems to be a more than reasonable figure to have full use of his property, and he repossessed the car. I don't think he had any basis to repossess the car, which is why he dismissed his case. And you certainly don't want to get involved with bankruptcies and payments, so you don't want this car back, because getting this car back will be more trouble for you than anything else.
Exactly.
I absolutely understand that, because then you're dealing with his creditors and whatever. I'm not trusting that whole situation. In any event, I don't think that you paying $2,500 towards the rental of the car over a 10-month period is unreasonable, and then he's whole. Then if he wants to spend money to have the car spruced up before he sells it, well, maybe he can get $8,500 for it, and then he's whole. So now everybody's happy. Judgment on the counterclaim for $2,500. We're finished. Thank you very much.
Thank you, Your Honor.
This court is adjourned.
I'm very happy.
Needed a car, I had a car.
I don't think it was an honest transaction on his part.
I'll keep buying and selling.
So yeah, I think he was just trying to get a quick payday.
So I just want to make sure I have this right. The defendant was paying the plaintiff $1,000 a month towards the vehicle that the plaintiff had a title loan out on, but instead of paying off the title loan so the defendant would have the car free and clear,
right,
he decided to keep the payments and not pay off the title loan.
Correct. Which means that even after he completed the payments, which he was halfway finished with, he could not have gotten clear title.
Yeah.
Because the title is with the loan company. And he's filed for bankruptcy, so you can't come against him. Slick.
Yeah, sticky